ಏನ್ ದುಡ್ಡು ಕೊಟ್ಟು ಕೇಸ್ ಫೈಲ್ ಮಾಡಿಲ್ವಾ ನೀವು ಮಾತಾಡ್ತಾ ಇರೋದು ಸರಿ ಇಲ್ಲ ದುಡ್ಡೇ ಯಾರಿಗಾದ್ರೂ ನಿಮ್ ದುಡ್ಡು ಯಾರಾಗಿರ್ಬೇಕು ಕೆಲಸ ಮಾಡ್ತಾರೆ ಮಾತಾಡೋದು ಬನ್ನಿ ಅಂತ ಹೇಳಿ ಬರ್ತೀನಿ ಬನ್ನಿ ಬನ್ನಿ ನಾಳೆ
Which will not
take any memos of fresh matters of family court, because all the matters that are numbered, the general direction that it will come. MFA matters also, don't give the memo. Yes.
Which your lordship kind permission.
All other memos you give to the court officer will see.
Urgent, how can you post matter? Very urgent is matter not reached last month.
Huh?
Last month posted before vacation, not reached. Matters were urgent before the trial court is MC case is pending. One case is withdrawn. Another case subsequently filed.
What is that?
Are the challenge petitioner
Write the urgency on the paper.
Yes.
And give it to the court officer. I'll look at it and give the date.
My lord, this matter surface proceedings, my lord.
Surface also. If the what is urgency, you please mention the urgency. I will look at this memo and give a date.
Mention the urgency, my lord.
Lord, one submission. Lord, the maintainability of writ petition was raised, objection raised, Lord. Lord, I'm not pressing that the orders on IA. Lord, only one prayer is I'm pressing that memo, Lord, last occasion, Lords have directed the matter may be dismissed without reference to bench. Lord, kindly have it tomorrow. Because I'm not pressing the prayer, main prayer.
That you can tell the registry also, I think.
Lord, I filed memo itself.
Then if it is filed, it will be considered.
Lord, kindly have it tomorrow.
Then when did you make that return that submission before the registry?
No, no, I'm
Why should you file a memo here?
No, I'm filing it in registry.
File it. If it is filed, it will be listed before the court on your submission.
Lord, there is urgency in
that we will not accept memos like that, because I'm giving a general memo every day, 90 memos for no reason, just like that.
No, if
and every memo I have to read all 90 memos a day.
As there is direction from this honorable court that the
The
repetition
moment you
dismissed.
comply with whatever the court said and it is brought to the notice of the
No,
rest, they will
court
post.
said that to file a separate writ petition.
No, you
Not
file
in
a
this-
memo saying that I'm not pressing for it.
Yes.
Then also it will be listed. So it's only for you to do it. Once you do it, general instructions or all the matters that are, they are compared with the office objections have to be listed before the court without any exception. Yes.
My lords, this matter is, we have complied with all objections, my lords.
If it is
And also-
compared, it will come.
My lord, but we filed it on 17th, my lord, it's already 10 days, my lord, and then a possession notice has been issued.
Please look into that. Why a matter which is already office objections are complied and ready, why it is not listed?
Please, my lords.
And you please find out from the officer why it is not listed.
Yes, my lords.
Yes.
Can it be tomorrow, my lords? Can it be had tomorrow? There is a
Why-
danger
what
of
is the
possession.
urgency?
My lords,
What is the urgency?
my lords, we have actually, the outstanding is 87 lakhs, my lords. I have given an offer for 75 lakhs for settlement, my lord, total settlement. And the default, genuinity of default is that my money is stuck with MESCOM form, my lord, for which I had taken the facilities, my lords.
Said, what is the urgency for tomorrow?
My lords, the section 14 order has been issued almost 10 days ago, my lords, and at any time they will take over, my lords. They had waited only for Diwali.
Symbolic position, still we can stop it. Not necessary that we should have.
My
it
lord, it's a
tomorrow.
residential house, my lords. If I'm thrown out, it'll be great danger, my lords.
You out like that. We'll see.
Please, my lords.
Yes.
Number 1, page wise adjournment, page 1, serial number 2,
Urgent. is very-
page number 1, serial number 2 to 4, page number 2, serial number 5 to 8, list number 2,
Number ಕೊಡು,
page number 1, serial number 1 and 2,
Serial number 1, my lord.
Yes.
Also for petitioner, my lord.
CS objection,
Serial
lords.
number one.
Matter may be heard, serial number 1.
Yes.
page number 2, serial number 3 to 4, 3 and 4, page number 3, 5, serial number 5, page number 6, serial number 6 to 13, page number 17, list number 3, page 1, serial number 2 to 4, page number 2, serial number 5 to 8,
File it, file. Date, see, there is not out of turn. I
Which
inform
one?
the, file.
I appear for response.
It can be
Inform the-
adjourned.
Fixed date, my lord, is
Yes. This is matter on
14th, 13th, senior, 14th,
Uh-huh.
14th. Is having one more case in High Court, Supreme Court, 14th.
This is a matter on 11th of November. Yes.
number 4, page wise adjournment,
Madam,
page
40.
number 2,
Lord,
serial number 6,
Serial
No.
number 2, my lord. Serial
Yes.
number
Page-
2. I have filed a memo for withdrawal of the appeal. Kindly be. Matter has been amicably settled with the claimants.
The memo is asking to withdraw the petition as the matter is settled amicably between the parties. Accordingly, memo is taken on record and dismissed as withdrawn. Next.
serial number, page
Right.
number 3, serial number 7 to 12, page number 4, 13 to 19, page number 5, 29, 20 to 25,
Lord, serial number 24, my lord. The Liberty General Insurance Company served unrepresented. Panel advocate may be directed to take notice, my lord.
Who appears for Liberty General Insurance?
V. Pradeep.
When he is there, I think they're looking, if necessary, we can dispose it off also.
Please.
Wait for the matter.
page number 6, serial number 26 to 30, page number 7, serial number 31 to 34, list number 1, for orders matter, serial number 1,
Petitioner, my lord. There is an objection raised by the office. Single rate may not be maintainable against more than one IA. The IA is the interim maintenance application filed by the respondent before the trial court, my lord. Hence, I confine this writ petition to the single IA, that is at annexure G. And other, I will file a fresh petition, my lord.
Office objection.
Office objection will be.
With regard to the maintainability is sustained. It line counsel for the petitioner submits that is confining this writ petition to,
Annexure G.
what is the IA?
My lord, it is under section 24 of,
There are two IAs, IA number 3, IA number 4.
yeah, IA 3, my lord.
You're confining it, this writ petition
IA
to IA
three,
number
IA
4.
three.
Is confining this writ petition to IA number 3.
Yes.
And in respect of IA number 4, he'll file a separate writ petition. The petitioner shall carry out the necessary
My lord,
amendment.
an interim prayer may be considered, my lord. Tomorrow there is a,
Huh?
tomorrow there is a case before the trial court. Interim prayer sought in this writ petition may be allowed. I will comply the other office objection.
Tomorrow the case is there before the court. I'm not going to stay the proceedings.
No.
I will not stay the proceedings. If it is a maintenance order, whatever it is there on that order, I will pass orders. I will not stay the proceedings of the trial court tomorrow. Even if an interim order is
That order may be stayed, my lord. IA number 3 may be stayed. Why? Because it has been ordered for 5,000 for respondent and other 3,000 for.
When
his
is this
daughter.
order passed?
6/8/25, my lord.
Carry out the necessary amendments. Let's just matter.
In the course of the day, I will complete, my lord. A date may be fixed.
This is matter day after tomorrow. The petition shall carry out the amendment. If the amendments are carried out, this is the matter day after tomorrow.
Much appreciated.
Number 2, Muniappa for petitioner.
Yes.
This is a petition filed against the orders passed by the trial court under section 125 of the proceedings.
Where is the order?
The order is at page number 31 to 35. 33 is the reasons assigned. He is aged about 70 years, my lord, the petitioner before the court. The respondent is the second wife. She is none other than the first wife's sister. 8,000 has been ordered, my lord. He is a coolie. He has no avocation. He is aged about 70
That
years.
constitutes the petitioner submits that. The court had granted 8,000 as maintenance. The petitioner before this court is aged about 70 years. He has no, what is his?
Nothing, he is an employee, he is a agricultural laborer, my
Admitted
lord.
that he is an agriculture coolie and paying an amount of rupees 8,000. The court, without considering all these aspects, had granted 8,000 rupees as maintenance. Considering the submission, they shall be stay on the condition that he shall pay an amount of rupees 4,000 by 5th of every succeeding month, and the arrears at 4,000 within 8 weeks. Either of the order not complied with, the stay granted by this court stands vacated without further reference to the court. The petitioner shall take out hand summons on the counsel appearing for the respondent and shall file a memo to that effect by 20th of November. If the memo is not filed, even on that ground also, the stay granted by this court stands vacated. Next three.
Cell number 3, Pancham already for petitioner.
Yes.
My lords, petitioner and respondent are husband and wife, my lords. The marriage
Where is
was,
the order?
my lords, at annexure A, please, my lords. My lords, the petitioner was directed to pay a monthly maintenance of rupees 45,000, my lords, and one-time litigation expenses of rupees
No,
20.
what is the amount that is sought?
50,000, my lords.
Court has granted 45,000. What's your income?
My lords, income is 70,000, my lords, income of the petitioner.
Let's
And-
see the order, how it is considered.
Please, my lords. My lords, para number 13, my lords. No doubt the petitioner has not produced any documents with regard to actual salary of respondent. However, in her application itself, respondent wife has categorically admitted that out of her salary income, she was providing education and maintaining the family, as the petitioner has not providing any thing to maintain family.
Have you filed your statement of assets and liabilities?
My lords, petitioner has filed, my lords, but respondent has not filed.
What is your income as per that?
Please, my lords. My lords, he is running poultry business, my lords. Income is 70,000, my lords. Paid number 39, please.
You are into business.
Poultry, my lords, poultry business. Poultry.
Bank statements are filed.
Bank statements are also filed, my lords. Respondent is a working woman, my lords. She is working as my lords, cluster resource person, my lords, and drawing the salary of 80,000, my lords. Her salary is more than that of the petitioner, my lords. And my lords, while when the petitioner was
The age of the child?
my lords, daughter is 21 years, my lords, and one son is aged 15 years, another son is aged 14 years, my lords.
Then how are you taking care of the maintenance of the children? Have you
Well-
paid anything till now?
My lords, all along he was paying
Not all along.
their
From the
education
last 3
expenses.
years, both of you are residing separately.
For last 2 years, they are residing
Then in
separately.
the last 2 years, what is your contribution to the family?
My lords, when he was doing well, my lords, he has purchased the property in the joint name of the petitioner and respondent. Again, in the year 2007, my lords. In the year 2016, he has purchased the property in his wife's name, my lords. Again, in the year 2020, he has purchased the property in his wife's name, my lords. All the documents are produced, my lords. My lords, the respondent, without filing my lords, the statement of objection to the main petition and my lords, her asset and liabilities, my lords, has filed the application under section 24 of the Hindu Marriage Act, my lords, and sought for the interim maintenance. My lords, the worth of the properties.
Please come. The petitioner husband is before this court questioning the order passed by the family court, whereby the family court had granted interim maintenance of an amount of rupees 45,000 from the date of the IA till dispose of the main petition, along with the one-time mitigation expenses of rupees 25,000. Land council submits that is doing a poultry business and his income is 75,000 per month, and whereas the salary of the wife is 80,000. However, it does not dispute the fact that he has been he has not paid anything towards the maintenance of the children, their educational expenses or otherwise. Considering all this, there shall be stay of all further proceedings on the condition that he shall continue to pay an amount of rupees 19,000 per month. And what about the educational expenses?
My lords,
Half of the educational expenses of the children shall be borne by the father.
Great.
And even the amount at 19,000 arrears like in the earlier order. And hand summons, yes.
Oblige.
Cell number 4, Arun Govindraj for petitioner.
What is annexure A?
No, annexure A is the order of the family court directing me, the wife, the petitioner before.
Why the main order to be dispensed with?
No, I produced the photocopy of the certified copy. The certified copy is with another counsel, she could not get it. I produced the photocopy of the certified copy.
I number 1/25 is dispensed with. Is filed to dispense the production of certified copy of annexure A is dispensed with for the present.
Yes. The direction, of the family court is now for me to file my affidavit of assets and liabilities when there is no monetary claim by any person pending before the family court. At the time, your lordship passed the order, annexure.
No, what is
annexure
impugned before this court now?
Before your lordship had passed an order.
No, what is impugned in this?
The order of the family court directing me to file the affidavit of assets and liabilities when there is no monetary claim pending before the family court at all.
You are not seeking alimony.
I filed a memo withdrawing my claim for alimony. Notwithstanding that memo, because your lordships in the earlier proceeding had directed both the parties to file affidavit of assets and liabilities because the alimony claim was pending. But now the family court insists there's a high court direction, therefore file your affidavit.
Your Honor, I am the respondent.
Who are you?
I am the counsel in the lower court, Your Honor.
They have not
We have
served-
not got the copies still, so I can't come on record.
Notice is not been.
It's coming up today.
Yeah.
It's coming up for the first
Objection
time.
was there, the respondent copy is not served, Your Lordship.
Is it coming for the admission?
First time, it's coming up for the first notice.
How will you
Notice is
get
not
the
even ordered.
papers even before the notice is given to you? Showing the respondent present in person?
Maintenance is being paid, Your Lordship. 7,500 is being paid up to date, it's updated, Your Lordship.
Land counsel for the respondent party in person is present and submits that and seeks time to engage the counsel. List this matter on next Monday. Land counsel for the petition to serve the copy of the writ petition on the counsel for
Yes,
the party in person.
your lordship has directed the family court to dispose of the matter before 15th of December because 2015 divorce petition filed by me.
Will serve the papers on him.
Matter is listed today for cross-examination.
Let it go on.
They're not cross-examining because I've not filed my affidavit of assets and liabilities.
Your Honor, I've already filed the assets and liabilities, Your Honor, based on this
No,
court's
what
order.
is, no, the main matter, what is the connection of filing these assets and liabilities?
Your Lordship, if I may. There's a lot of earnings.
The papers from him and I'll take up the matter tomorrow. List this matter tomorrow, then counsel for the petitioner shall serve the copy of the petition on the counsel for the respondent. Yes,
Oblige.
on the, not respond, on the party in person. Yes, next.
Cell number 5,
Yes,
Petitioner Lodge.
Sridharan.
He wants to file a memo, Your Lordship, on the regard.
huh?
He wants to
Filing
file
a
a
memo.
memo.
What memo?
Okay.
Just no notice is not even issued.
Okay.
What is this? What is the anxiety? I don't understand. Yes,
Lordship, the councillor report was awaited, Lordship. It has
Huh?
been councillor's report. As per the earlier order,
is here. When is it? There is some report here. What is this? This is dated 23/10. This is 29/8. This is the latest one. Anita? Ask her to carry out this change till BM.
restitution.
Do you appear for?
petitioner, Lordship.
Who is the petitioner?
Brinda,
Wife.
wife,
the mother.
wife is the petitioner, Lordship.
Yes, the report of the councillor says that the boy is too comfortable with the father, he is enjoying every minute, and the mother is more apprehensive about so many things. And ultimately, the remarks of the parents must recognize the importance of providing their child with a peaceful and emotionally secured environment. When personal grievances and egos like precedence the child's needs and well-being are often neglected. Both parents should consider constructive co-parenting, which will contribute significantly to the child's emotional stability and healthy development. In fact, the counselor observes that the boy is very eager, he wants to meet the father on every occasion, and they are spending 2 hours time, and father is not showing any kind of emotional issues.
Lordship, I may be permitted, a date may be assigned. I'll look into the report and I'll make my submissions, Lordship. Because there are health issues that has been cropped up after the visitation, Lordship. Every time after the visitation, the child has fallen sick, and last occasion after the 18th, he was admitted in the hospital.
What is the connection between the two?
Lordship, the child is having a shivers and chills, and it keeps on saying that he's asking me to call him Appa, he's asking me to call me Appa. But that uncle, I don't want to call him Appa. And he keeps murmuring that.
No, the mother finds her
And
something.
also, they're feeding the child, Lordship. We brought this to the knowledge of the counselor also, that after the child is complaining of the stomach ache, they are feeding child food. We have told that to the counselor, but she said that is not an issue. But I would like to submit, my Lordship, there's a discharge summary, and I'll file a memo. He was hospitalized at 1:30 a.m. complaining of stomach upset, and he has fever and chills, Lordship.
He has come because he met the father.
18th he met, 19th morning 1:30 a.m. he suffered, Lordship. It's not only on 18th, Lordship. Every visitation, after every
If he doesn't
visitation.
meet the father also, he will get all this. When something has to come, it will come. And
Please,
please
Lordship.
don't attribute all this to the father. That's
Lordship,
not right on the part of the mother to do all this. Let this
No, Lordship.
this visitation continue before the counselor for another 6-7 weeks. We will see after
Lordship,
that.
there's a difficulty. She's the only working woman. She has to get the child every time from Jalali to the
Then you suggest something
designated date and Saturdays may be recommended, Lordship.
Huh?
Designated dates.
That's what Saturday only I'm saying.
Respondent used to come from Mangalore, madam.
Saturday only I'm saying. Saturday let her go. Only one day.
I may be given a date, Lordship. I'll look into the report and I'll make a submissions before this.
Whatever your submissions are, still I'm going to grant the visitation. So it doesn't
It,
make
it,
any
it,
difference.
I agree, Lordship. Visitation right has to be
No, I
granted.
will-
Only
I will-
my concern
I
is
will-
the frequency,
I'll
Lordship.
record all your submissions. I will ask the registry to give you a copy of the report and still I'll grant the visitation. That shall continue on every Saturday for 2 hours in the presence of the counselor. And let it go on for some 6, 7 weeks, 7 Saturdays. Let me look at the report, then we'll pass a final order.
Please, Lordship.
This court has passed an order on 31/7/2025, whereby the father is permitted to exercise the visitation before the counselor in the Bangalore Mediation Center and directed to place a report before the court. A report dated 23/10/2025 is placed before the court. As per the report, the boy is very comfortable with the father. And all the 3 visitations proceeded smoothly. The boy is comfortable and happy in his father's presence, showing no signs of resistance or distress. Even when the mother had stepped in briefly for about 10 to 15 minutes, the boy remained comfortable with his father. The counselor also observes that the petitioner mother appeared cautious and observant throughout the sessions, closely monitoring interactions between the father and the child. She expressed concerns about the father's past anger issues. But however, during all the observed visitations, there were no signs of aggression, agitation, or inappropriate behavior from the father. When the counselor spoke about reconciliation or maintaining cordial communication, the petitioner expressed her unwillingness, citing past difficulties with her husband and in-laws. The counselor also observed that the boy eagerly looking on every occasion, the boy is eagerly looking forward to forward, particularly to see what his father brings to him. He enjoys eating the food fed to him by his father and appears cheerful in his company. Next paragraph. When counsel appearing for the mother submits that every time after the visitation, the boy is having is developing health issues. The father is feeding him the unwanted food. Further, she has to admit him in a hospital at 1:30 after the visitation, 1:30 a.m. after the visitation. It is submitted that the boy is not comfortable interacting with the father. Once a copy of the report is given to her, she would file her objections to that, and then the court can pass appropriate orders. Next paragraph. And counsel appearing for the and it is also submitted by the mother. The same paragraph submitted by the mother that every time she is coming all the way from
Near Jalali, Lordship.
she stays near Jalali, and from there she has to travel to the family court, to the mediation center. It is submitted that she's a single mother, she's working, and she has to take care of the child. Next paragraph. When counsel appearing for the father submits that on each date of visitation he is coming from Mangalore. He is coming from Mangalore to meet the child. It is submitted that the boy is very comfortable as per according to him, and also as per the report of the counselor. In those circumstances, the submissions that are made are, are made without any basis, that the boy is not comfortable. Then council submits that the same arrangement may go on for some more time, so that they would give an opportunity to the father to, to develop bonding with the child. Next paragraph. Having heard the counsels on either side, there is the report that's placed before the court. Peruse the report of the counselor. The counselor's report is very clear about how comfortable the boy is while deciding the issues pertaining to the visitation, oblique custody of the child. The whole concern of the child, of the court, is the well-being of the child. The boy aged about 3.5 years.
3.5 years.
Boy is aged about 3.5 years, and he is comfortable in the company of the father. The mother, whatever the differences between the mother and the father, this court is not concerned with the same. And it's only about the well-being of the child. That is the primary concern of the court. The report clearly demonstrates that the boy is comfortable, and whatever are the concerns that are raised by the mother in the light of the counselor's report, at this juncture, this court is not inclined to consider. In the interest of the boy, as well as in the interest of the parents, this court deems it appropriate to continue this arrangement for another 6 weeks. And basing on the report, and after 6 weeks, the counselor shall place the report before this court. Basing on that, the court will pass further orders.
Memo may be considered, Lordship, along with the medical reports.
File it in the registry.
Please.
This court is, accordingly, this court is passing the following order. On first November is a holiday. 1st November is a holiday. Huh? 8th also appears to be holiday. Huh? Why 1st is holiday? Oh, November 1st. Then we'll do one thing. We'll have it on 1st and 8th, or those Saturdays. We'll say 31st and 7th, Friday in the evening.
Friday evening.
And wherever there is no holiday, that day we will have it on Saturday. So
Friday, it will be difficult. She's a working woman. She'll not get leaves, Lordship. That's the difficulty. Only thing, Saturday.
On 15th, 22nd, 29th, 6th, we'll say instead of earlier I said 6 weeks, make it 4 weeks. So 15, 12, 29 and 6, the father shall exercise the visitation before the counselor for 2 hours in the Bangalore Mediation Center. And the report shall be placed, this matter on 10th December, and by the time the report shall be placed before the court. Number 2, the registrar is the registry is directed to give a copy of the report dated 23/10/2025 to both the councils. Yes.
Grateful, Lordship.
Akshay Ramchandra Uddar for petitioner.
My lord, we have been served with only a notice, page of a notice.
Uh-huh.
We have been served with only notice, my lord. Petition copy isn't
It's
served.
not there. Serve on him.
Yes, my lordship. We will.
When do you want?
My lordship, I am for the petitioner, my lords. Here, respondent has filed seemingly miscellaneous.
Why the memo
my
is
lords.
full?
My lordship, it is the MC case, my lordship.
Memo for posting. The above petition may kindly be posted for hearing. Just like that. No urgency, nothing.
My lordship, I will explain, my lordship.
Not explain, your memo should explain, is it not?
Yes, my lordship.
That's what I feel so, like, just like their memos are given. Because you have given the memos, I have to give a date.
My lordship,
Give the papers to him day after tomorrow. Then counsel shall the petition saw the copy of the writ petition on the counsel for the respondent today. List this matter day after tomorrow.
Cell number
Much
7.
obliged, my lordship.
Cell
Yes.
number 7.
I comply the order of the Honorable Court, my lord, and also filed the claim.
What is that?
The Honorable Court has granted interim stay, my lord, depositing 10,000.
No, that is till he comes. No, yes, he's here, please argue.
Next week, my lord.
No. Where is the impugned order?
Impugned order is, my lord, page number 53, my lord. Relevant portion is, my lord, page number 56, my lord.
What is the order?
My lord, 20,000 has been ordered by the trial court, my lord, based on the document produced by the trial court, my lord.
20,000 per month to the
Yes, ma'am.
children,
Children's, my lord.
including school fees.
Including
What is
school
your
fees.
salary?
My lord, my salary is 34,000, my lord. It is
34,000.
admitted in 34,000, my lord.
What is mother's salary?
Our salary is 73,000, my lord.
70?
3,250, my lord.
Is it correct? His salary is 34,000.
34,000.
Then what is this order of 20,000?
My lord, what has happened is, my lord, I have produced certain document to show that, my lord, we separated, my lord, in the year 2016. Soon thereafter, my lord, in a family partition, he had got 12 sites, my lord, in Bangalore city. He alienated
Is it getting him a monthly income?
My lord, he sold that, my lord. He sold that in 2017.
This order is passed when?
My lord, in
This is on
2025.
16th July 2025.
Yes,
So the
Suppress
site,
that fact, my lord, even in the statement of affidavit and liabilities,
so 2017 site that is sold, what is the amount he got?
six sites he has sold, my lord. 6 sites he is retained, my lord. I don't know whether he has sold thereafter, my lord. I am not aware of that. My lord, he is sufficiently.
According to you, how much is the amount he got from selling those sites?
My lord, he sold the sites to his mother, my lord. Kindly see, my lord, para number, my lord, page number 56, observation of the learned judge, my lord. Bona fides, my lord, are not correct. That is what the finding of the learned trial judge, my lord. My lord, permit me to read page 56, my lord, in internal page 8.
Yes.
In view of the judgment, when the wife is getting a salary, she is also obliged to contribute in the maintenance of the children. Learned counsel for the respondent in his argument vehemently argued that respondent, apart from his monthly salary, has sufficient immovable properties in his name. To show the same, the respondent has produced registered partition deed dated 24/3/2011. Under the said partition deed, the petitioner has acquired 12 residential sites as his share. Learned counsel for the respondent further argued that in order to escape from the liability, he has executed a nominal sale deed in favor of his mother in respect of 6 residential sites. And to show the same, he has produced a certified copy of the sale deed dated 15.
No.
Of course, it is true that.
No. Because of this nominal sale deeds, he has not received any amount from that.
As per the sale deed, some 6 lakhs is shown, my lord.
So if the children are entitled for any share in that, in view of the disputes, you can file a suit for partition. Whatever it is, you will get it. That's now, when we're granting maintenance, we have to see about what is the income, what is that he is having. His income is, how much it is? 34,000. So out of 34,000, if he pays 20,000 towards education of the child, how is it right?
My lord, I am in a residential. I am staying in a residential.
Your salary is
71,000.
71,250.
73,000, my lord, after deducting 71,000.
So
My lord, I am
even the
living in a-
contribution to the family should be proportionate to your income.
But I am in a residential. I have 2 children, my lord. 2 children.
That's
are
true.
there. 2 children. One is in a 10th, my lord. One is in 7th standard.
We'll make it 10,000.
But 15,000.
And-
But because, my lord, every year, my lord, 2 children's school fees is, my lord, approximately 1,70,000 rupees. Only school fees, my lord. Apart from transportation, my lord, food, clothing,
Father
etc.,
whose salary is 34,000 per month. Per annum, how much is his salary? Is 4,08,000. In 4,08,000, you are paying how much the school expenses?
1,69,000, 70,000
1,70,000 per
for
month,
both the children.
per year.
Per year.
Hmm.
It's apart from, my lord, transportation, my lord, clothing, etc.
You're joining them in a school as per your financial capacity. And what is a father can do in that?
My lord, that is very nominal, my lord. 80,000 per child, my lord, in Bangalore per annum.
Then we'll see something like this. Then
My lord, I'll
you
give
said
it to your
1 lakh, no,
lordship,
no,
my lord.
one minute, 1 lakh,
1,70,000.
70,000.
One lakh 69,035, my lord, to be specific.
So, 30% of it, looking at the proportionate salaries of both the parents, it comes to 51,000. Educational expenses. You pay that.
Ready to pay, my lord. It may be, my lord, kindly see, my lord, 34,000 rupees I've been getting a salary, my lord. After deducting, my lord, 30,000 has been come, my lord. I also paying some EMIs, my lord.
Hmm.
And also, my
No,
old parents
as
is
per
there,
the
my lord.
order that is passed by the court,
Yes, ma'am.
you have to pay 2,40,000 per annum.
Yes, ma'am.
So you pay 51,000 towards school fees
Yes,
and
Entire
51,000 towards education and 8,000 towards the maintenance.
My lord, and one more submission, my lord. Up to 2020, my lord, entire school fees has been paid by the father, my lord.
You want
At
refund
least
of
he is
it?
capable, my lord.
Yes, please. So then how are you paying then?
Taking some loans, my lord.
How
Then,
also you take loan?
now is difficult, my lord. I'm,
Right.
my lord,
Each
some
side,
what?
my lord, the cost of each side in Bangalore city, as I'm told, my lord, is more than a crore, my lord.
If my lord is entitled, my lord, if they are filed partitions, my lord, that is not in dispute, my lord.
No,
My lord,
5,000.
it will make
No,
it
we'll
six,
make it 51,000 and 10,000.
my lord. It will make 6,000, my lord, and 50,000 rupees legal expense.
Please come. The present writ petition is filed, agreed with the orders passed in I number 4 in MC number 6 of 2018 dated 16 July 2025, whereby the children are granted, whereby the father is directed to pay an amount of rupees 20,000 per month to the children, including the school fees, from the date of the application till disposal of the petition. Land council appearing for the father submits that the father's salary is 34,000 and the mother's salary is 73,250. And in spite of the same, the court had directed the father to pay 20%, 20,000 as maintenance. It is on the higher side. It is submitted that when the mother is earning more than the father, the court ought not to have passed such an order. It is submitted that till 2020, he was taking care of the entire expenses of the children.
In that time, my lord, school fees is 50,000, my lord.
At that
Per child, my
time,
lord.
the school fees is 50,000. It is submitted that the court, without considering the financial status of the father, has granted the maintenance. Next, parallel and counsel appearing with the respondent submits that in the partition that took place in the year 2011, he got 12 sites. He got 12 sites, and in that, he has sold 6 sites on a nominal sale date to his mother, which clearly shows the intention of the petitioner. And the court, considering the said facts, taking into consideration the said facts, the court had rightly granted, and there are no grounds to interfere. Next part. Having heard the land counsel of the petitioner, land counsels on either side peruse the material on record. As far as the salary, as far as the salary of the husband and the wife of, that is 34, husband 34,000 and the wife 73,250. There is no dispute about the fact. Then coming to the partition and the sites that fell to his share, according to them, a nominal sale deed is executed in favor of the petitioner's mother. And there is nothing on record to show that those sites are fetching any income to the petitioner. In those circumstances, while granting the maintenance, this court cannot go into that aspect. If the respondent children are entitled for the share, if they have their own, they can go before the appropriate forum seeking the relief. Then coming to the maintenance, considering the salary of the mother and the father, this court deems it appropriate to pass the following order. One, the father shall pay an amount of rupees 5,000 each to both the children towards maintenance, and shall pay the educational expenses of an amount of rupees 51,000 per annum towards the education of both the children. Accordingly, the order dated so and so, passed by so and so is modified. Yes, next.
Number 8, Manjunath H for the petitioner, Anand S.
Appear for the respondent, but today I'm filing the wakalat minutes.
In spite of service of notice on the council as well as the respondent, they have not chosen to appear before this court and they have not complied with the order submitted. Mother has taken the child out of Bangalore during vacation. Mother is directed not to take the child out. So unless this order is passed, the mother will not come before the court. But I am indicating, Mr. Counsel, please tell the mother if this is the conduct, I will shift the custody to the father on the next date of hearing itself.
Please.
And let the child and mother both be present at 5 o'clock in the chambers on this matter on 30th. On the day, all the children, the mother, father and the child shall be present before the court in the chambers.
Highly obliged. My name will be, it's already shown.
Mr. So-and-so submits that he has instructions to
Kindly direct one copy set of copies.
file.
One set of copies.
Give him.
It's already given, but I'll give an additional.
Give him.
No problem.
So-and-so, delete the name of so-and-so, and so-and-so submits that he has instructions to file wakalat. Then counsel for the petition shall serve the copy of the petition on the counsel appearing for the respondent.
Please, obliged.
Number 2, for IA order, sale number 1.
For the respondent bank.
For petitioner, my lord, senior is not well, my lord. Kindly,
Yes.
senior is not well, my lord. Kindly 2 days.
Every time the matter comes, the senior will not be well.
Position notice is under challenge. More than 4.5 crore loan dues. The interim order was granted in February 2024. Till date, not even a single penny has come
By
forward.
2024, an order on payment of 10%.
Oh, no, my lord, only day after tomorrow, my lord. Kindly request.
I have serious objections. Will not let him go before DRT. Even if any order is passed, let him be delivered to go before. 34 is under challenge. By hard difficulty, I got this.
Friday, my lord. Kindly request, my lord.
In fact, I filed vacating of interim order in the month of February 2025.
No, my lord. Date when we fix, my lord, 13, my lord. Request, my lord.
That additional condition of another 1 crore may be imposed, my lords, because more than 4.75 crores is the loan dues. And after the grant of interim order, there is not even paying they're not continuing to pay the EMIs.
So what is outstanding as of
Outstanding as on today, it's more than 4.25 crores, my lords.
And what is the interim order?
Interim order was to deposit, staying of the position notice, subject to deposit of 20% of the loan dues then. That was complied. But since then, no continuity of EMI is not there. More than per month, he has to pay more than 7 lakhs to me. When that is calculated, it's more than 1.4 crores.
Friday, this is matter day after tomorrow.
Interim order extension.
And no further adjournments will be granted. The cause list should reflect this.
Yes, ma'am.
Interim order earlier granted is extended till then.
Sale number 2.
In the cause list also, this should come, that the no further adjournments will be. Wherever I said no further adjournment, that should reflect in the cause list.
List number 2, Kaleshappa case for petitioner,
For respondents, ma'am.
Sadhana Desai.
Your lordship, we haven't received the petition copy yet, your lordship.
Anyway, they want an early hearing. That's a copy.
Your lordship,
IA is for early hearing.
indeed, your lordship. It has been moved by the petitioner.
I understand.
And the stay has been vacated.
10% of the amount?
stay has been vacated, Your Lordship, because last date.
This is matter on 9th of December, IA number 1 of 25 is filed seeking early hearing ordered.
Cell number 3,
Yes,
Karumbaya TA, petitioner.
My Lord, I may be permitted to withdraw this petition, my lord, with liberty to approach the DRT, my lord.
I don't.
Thank you. Application allowed.
this is a repetition of 2024.
Yes.
Status quo from 24. Why you want to withdraw now?
These are my instructions, my lord.
My lord, first and foremost, my lord, the writ petition itself, my lord, not maintainable. The sale, my lord, assailed before this honorable court. In fact, my lord, if they're seeking a liberty without, my lord, any condition, my lord, I don't have any objections to, my lord, to go before the DRT.
Now, if it is subject to the limitation,
Limitation, definitely, my lord. That
then
will not,
nothing remains. That limitation is over long back.
is their risk, my lord. They're seeking liberty from this honorable court to, my lord, go before the DRT, my lord. Let them go. I don't have any objections.
Yes, my lord. Within 4 weeks, my lord.
No. I'll not grant any time for you for, say you're at liberty to approach the DRT subject to the law of limitation. If that is law of limitation,
Yes, my lord.
your time will go long back. Please get it fast forward.
Okay.
Grateful.
Cell
Yes,
number
next.
4, Peshawar Agnihotri, Puran.
Pass over, my lord. My counsel will come. I am the
My lord,
petition.
Like that, there
I
can't be
appear-
any mention by a party before the court.
Yeah, I am aware, but he is coming. Please. pass.
But you cannot make a mention.
I
The list
appear
also
for,
contains, please don't make a mention.
My lord,
I
I appear
appear
for
for the
respondent number 1.
petitioner in
I seek weeks time to
4.1, my
file
lord.
objection.
My lord, even I seek for 2 weeks' time to file objections to the IAs filed, my lord.
What objections? First of all, let's see how is it maintainable. Pass over.
Cell number 5. Cell number 5.
Respondent bank, my lord.
Appear for R2
Yes.
purchaser.
Is this a matter that came up on the last occasion?
Yes, my lord.
In fact,
Please
it was
argue, I'll pass orders. If they are not coming, what to do?
the writ petition challenges, my lords, the order of the DRT rejecting their essay.
Now, there are as many as 1, 2, 3, 4, 5 petitions.
My lord, this is the
Right.
fourth
The
sale
earlier-
notice, my lord. Fourth sale notice being challenged, my lord.
No, I'm asking, there are these many petitions. What
Every
are-
time they issue a sale notice, writ petitions are filed.
So let's understand. So WP 7071 is filed questioning.
My lords, the order passed by the debt recovery tribunal, my lords, in essay number
16 of 2025.
16 of 2025, 28th of February 25. This would what would remain, my lords?
No, 20?
28th February.
2025 is the order question.
Yes, that's the only one which would, with great respect,
Then let's see this WP
188811.
18811.
That is with respect to earlier sale notices, my lord.
So
which
that
got-
it becomes
I'm sorry, yes, my lord. It got,
Then,
Lord,
no,
sir, can I-
please give me the date of the sale notice.
date of the sale notice, my lord.
My lords, 1/7/2024 was the earlier sale notice.
2024.
Can I make a
Coming
mention,
to
my lords?
WP, yes.
Lords, can I request if the matter, lords, I'm suffering from laryngitis. I am unable to argue the matters, my lords. Can I request if your lordships could accommodate by 1 or 2 days? Lords, I'm prepared in the matter.
No, as far as 5.1, 5.2, 3, 4 are concerned, they have become infractions.
Lords, I'll be appearing.
Some other counsel is appearing, my lord. for
So
that.
what I do is 5.1, 2, 3, 4, I will dismiss all these 4 because they have become infractions.
My lord, one submission.
5, we will hear it.
My lord,
Day after tomorrow.
why it is clubbed? Because, my lord, in those writ petitions, when the reserve, in the earlier sale notice, when the reserve price was fixed for 20 CR, there they have filed an undertaking affidavit, my lord. For that reason, it has been.
So it has to be heard along.
Yes, my lord.
List, it is submitted that the senior counsel appearing for the petitioner is unwell. This is matter on, when do you want, on 30th?
Lords, 30th, I'll take a chance on 30th, my lords.
30th or looking at the way his voice is, I think 30th is
Lords,
not
I
the.
can't say anything.
Yes, we'll have it on 4th November.
Please.
Yes, 4th November as
Could it
part
be on, could it be on, could it be on 5th November, my lords?
Yes, 5th November as part. Yes.
Preliminary
Please.
hearing, cell number 6. 6. Rudra Bhushan for petitioner, KV Lokesh.
Yes. KV Lokesh. Where is the counsel for the respondent? No representation on behalf of both the counsels. List this matter for dismissal on 11th of November. Don't extend the interim order. Yes.
Cell number 7. Manjunath MV for petitioner, Narayan Swami D.
Yes.
I represent respondent, Mila.
Any interim order in this?
The first time not appearing. There is no interim order. Notice is ordered, Mila, on the last.
No interim order. No representation on
also
behalf
not
of the petitioner. List this matter for dismissal. Counsel for the respondent is present. List this matter for dismissal on 19th.
Much obliged.
Yes, 8.
Appearing for the petitioner in this case, my lordship, seeking an interim order, my lordship. An order has been passed by the 30th ACMM in criminal miscellaneous 4680 of 2025. They want to take possession of the property, my lordship, where I am staying.
Who are you?
I'm the petitioner, my lordship, petitioner Power Systems. I'm the one of the borrower. I'm the partners in that, my lordship. So they say due of rupees, my lordship.
So what is wrong with the order? If you take the money and you don't pay, they will take the position. What is wrong with that?
There were business losses, my lordship. We have given a OTS scheme also, my lordship, where we are intending to settle the amount, and that is under consideration.
No, if a 14 order is passed, there must have been a notice under 13.2. What is your reply to the 13.2 notice?
My lordship, this same property was subject matter of another partnership firm where the entire dues have been cleared, my lordship. They had undertaken to release the property from the partnership. Apart from this, there are other 3 properties which are there.
The first question is 13.2 notice. What is your response to that?
My lordship, we had not received any notices, my lordship. We had not received any notices. The paper public, the affixture was not done. We were not aware about the notices.
How the 13.2 notices, sir?
It is served by way of my lord RPAD and my lord 13.4, my lord, we have affixed it. We have my lord affixed in the conspicuous part of the secured asset. We did a paper publication. Everything is done, and pursuant to that, we have filed an application under section 14 that came to be allowed. My lord,
No, have you stated so in your petition?
yes, my lord.
13.2.
Yes,
No,
ma'am.
if they place before this court that RPAD to show that the notice is served on you, and also they'll file the photographs to show that this notice is affixed on the conspicuous place in the residential building, as you say you're staying, then I'll dismiss this petition with exemplary costs of 20 lakhs. If you are ready for that, please make any submissions, or else I'll dismiss this petition just like that.
My lordship, I have not received any notices, my lordship.
I'll record that.
Yes, my lordship. The party is also present.
Not party. Party instructions is what you're saying. No, he will. So I'll take up this matter. Please come. Then counsel the petitioner submits that either they have not received a notice under 13.2, 13.4. Now the magistrate has passed an order under section 14. Then counsel appearing for the respondent bank submits that they have sent the notice under section
13.2 as well as 13.4 both. 13.2 as well as 13.4 both.
13.4 under RPAD, and the same is served on the respondents, and they have also affixed the same on the conspicuous place on the said building, and he'll produce the same. List this matter day after tomorrow.
My lordship, they want to take possession, my lordship. Till then, my lord, we are ready to what you call.
And if any of the submissions that are made with the petitioner are not correct, looking at are not correct, this court, it is also indicated to the petitioner that this court would impose their dismissal at petition with exemplary cause. The party is present before the court on instructions from the party. Then counsel of the petitioner submits that they have not received the notice. List this matter day after tomorrow. Produce all that. Tell your client is going to face it. 20 lakhs would be the costs that are going to be imposed. Tell him and please talk to him. If you have any reservation, again, please come and mention, or else on that day, no other, once I have all that, I'll dismiss it with 20 costs, 20 lakhs. Yes.
Cell number 9, Suresh V.
That's one humble request, my lords. I'm
You are
sorry.
for the petition or respondent?
My lords, I'm for the petitioner in serial number 6, my lords. My lords, I was held up in some other court, my lords. My lords.
What happened?
My lords, interim order has to be extended.
Why should we extend the interim order if we don't argue?
My lords, I will argue today itself. My lords.
Pass out the matter 6.
Yes, pass.
Cell number 9.
Inform the other side counsel also. Yes.
My lord, we filed a section 14 petition in the month of January 2025, my lord. The magistrate is.
Memo for dispensation of notice to
This
respondent,
is the
right?
respondent, borrowers, my lord. They are the borrowers, my lord.
You are?
I am the petitioner, I am the bank, my lord. I am the financier. We filed a section 14 petition before the honorable magistrate. Magistrate from the January, it is not passing the order. We are requested your lordship to direct the early disposal of the petition.
Memo is filed seeking dispensation of notice to respondent borrower. It is submitted that their presence of this petition was not required, as they're only seeking a mandamus for to dispose of the pending application. Accordingly, this is an order on this in memo. Accordingly, the memo is taken on record and notice is dispensed with. The present writ petition is filed. Next order in the writ petition. The present writ petition is filed seeking the following relief. Extract the prayer portion. Then counsel for the petitioner submits that they filed the surface proceedings were initiated when?
My lord, section 14 we filed in the month of January 2025, my lord. On 17/1/2025, my lord, page number 15.
It is submitted that the respondents have availed a loan of 1 crore 25 lakhs. The amount was to be repaid together with floating rate of interest for a period of 168 months by way of equated monthly installments towards the collateral security for repayment of the loan amount. The respondents have also deposited the title documents in favor of the petitioner bank. When they failed to pay the installment, the account was classified as non-performing asset on 1/7/2024, and the proceedings under the Surface Act were initiated. A notice was issued under section 13(2) of the Act on 2/9/2024. And the same was served on 14/9/2024. That thereafter, they filed an application under section 14 of the Surface Act before the 10th Additional Chief Judicial Magistrate on 17/1/2025. Now it's a grievance of the petitioner bank that no orders were passed on the said application, considering the submission and the fact that the application is filed as long as back on 17/1/2025. The 10th Additional Chief Judicial Magistrate is directed to pass appropriate orders on the pending application within a period of
15 days.
Within a period of 4 weeks.
Cell number 10.
Much obliged.
Yes.
Okay, for the caveat.
Lordship, I'm seeking interim order on the sale auction notice.
What happened to this?
Your Lordship,
1 minute,
symbolic
1 minute.
possession notice was given. Sorry.
Why is it today here? Who? It was passed yesterday. Hmm. No, she should do it when some order is there. She should take it as, when she has taken it in the morning or afternoon.
ಎಷ್ಟು ಇದೆ amount? Action date and time ಇದು ಕರೆಕ್ಟ್ ಆಗಿದೆ. Earnest money deposit 20 ಎಷ್ಟು ಅಮೌಂಟ್ ಎಷ್ಟು ಅಂತ 66.
Yes.
Lordship.
Yes.
I'm appearing for the petitioner, Your Lordship. I'm seeking interim order on the sale auction notice issued
Why?
by the respondent bank.
Why should we grant an interim order?
Lordship, this symbolic possession notice was issued during 4/10/2024, Your Lordship. After that, the matter was referred to Lok Adalat. The petitioner and the bank, the respondent bank appeared before the Lok Adalat and they actually settled the matter, but not in the writing. The petitioner undertook to repay the amount and substantial amount has been paid, Your Lordship.
What is the
And,
amount outstanding?
66 lakhs, Your Lordship.
66,81,970.
If you're ready to pay. Who is stopping you from paying that amount?
Lordship, we require a reasonable time of like 3 months.
That's 4/10/2024. Now we are in,
But
where are
sale
we?
notice has been issued now, Your Lordship, because the
No, but
matter
you are
was.
waiting from 1 year. Why should the bank wait for you till 1 year?
Substantial amount has been paid with for the
No,
one account.
outstanding is 66 lakhs.
Yes, Your Lordship.
No, if you want to settle, you have to settle by paying the amount. Why should we say?
We
Why
will
should we
settle, Your
stay
Lordship.
the
just-
notification?
We require just 2 months because we have kept one property for the sale since there is issues with the transfer of Khata.
Please tell the
certificate.
court, what are you doing from 4/10/2024 till this time? When did you pay the amounts? Substantial amounts you are referring to. When
Yes,
did you
Your
pay?
Lordship. Yes, Your Lordship. I have paid, Your Lordship. Bank statement has been attached. Annexure F, Your Lordship.
No, you can tell the court. You must have stated so in your petition also. What are the substantial amounts, when and where, how they are paid? Please refer to that. Come to your petition. Let's see. Nothing. Without stating any of the facts, just like that you come to the High Court, file a writ petition and say auction notice to be stayed. Why would the court interfere?
Lordship, just 3 months time, Your Lordship. One
No, just now
property
you
is-
said 2 months. Now you have increased it to another 1 month. Just now, a minute before you said 2 months.
Okay, 2 months may be granted.
Why
Your
should we
Lordship,
grant?
Because we have kept one property for sale because of.
What are you doing
issues
from
and-
1 year? That's what I asked you.
We had
You
paid
didn't answer to
substantial
that.
amount, that's why, like, I have filed the bank statement also, Your Lordship, that it has been reflecting. The
What is
substantial
reflecting?
Substantial amount what we
You
have
can,
paid.
you please look at the bank statement and tell the court, pass over. Yes.
Cell number 11. Karu pays for petitioner, Vignesh Shetty.
Kindly pass over the Lordship.
I beg to appear on behalf of State Bank of India in this matter.
Huh?
I beg to appear on behalf of my lord first respondent. This one court directed me to accept the notice. What had happened, my lord, they're seeking certain release of the vehicle. And my lord, I need some time to, my lord, file our objections because it is already seized. That's my instructions.
What is that?
My lord, the vehicles has been, my lord, already seized by the bank. I need some time to, my lord, file my statement of objections in this matter. They're not seeking, my lord, release of the vehicle they're seeking. Ultimately, they're seeking the final relief. I need
It's already seized.
Already seized. That's what, my lord, I got instructions.
Then comes to the respondent submits that the vehicles are already seized and he needs to file his objections. List this matter on 12th November.
One, my lord,
12th November. Yes, next.
Cell number 12.
Here for petitioner.
Yes, sir.
Yes, Lord.
Yes.
Lord, in this case, this petitioner questioned the correctness of the order dated 6/10/2025 passed by the London Magistrate under section 14 of the Surface Act Annexure D, page 54, Lord. Lord, this petitioner, in order to purchase this property, a residential house, Lord, this petitioner,
No,
sir,
what we
avoid.
do is, who is the respondent?
Pardon, Lord?
Respondent is who?
The bank,
Which bank?
this Piramal Capital and Housing Finance, that is in page number 5, Lord. On 3/11/2023, he availed the loan, my lord, by executing the mortgage deed, my lord.
In these matters, without hearing the other side, I will not pass an
That
interim order.
because that, by virtue of this order, my lord, that even this.
This order passed by the magistrate.
My lord, Annexure D, page 54, 6/10/2025. my lord. The art certified copy is obtained on 15, my lord. Kindly see page 62.
We
my
will,
lord.
whatever is the action, we can always, we can antedate it, we can definitely.
One submission, my lord. This petitioner, my lord, kindly see for a moment,
Because
my lord, Annexure C, page.
in these kind of
Annexure
matters,
for a moment, my lord.
without the instructions of the bank or any of the respondents.
For a
passing-
moment, my lord, kindly see Annexure
So
C.
please understand, the scope of interference of this court in this writ petition
Because this
itself is very
petitioner is
limited.
ready, my petitioner is ready, it is only
All
a
that,
residential
all,
house.
because if you're ready, what are the thing, what is going on, I don't know.
Because
Unless
that
the
what
bank is
happened, my
before
lord, I
the
will tell
court.
before this court, my lord. My lord, for a moment, my lord, bear with me, Annexure C, my lord, page 39, my lord.
I'm not going to, I mean, adjourn this matter for after 10 days or 15 days. I will even take it up day after tomorrow, provided you.
Because for today, they are trying to dispose us, my lord. That is
They will
only
not
the,
dispose us
and also
on,
even this court
14,
can
they
grant
will
some
not
conditional
dispose us.
stay, my lord, because if there, it is a only residential house,
So
they,
first of all, you tell the court, why should I interfere in this?
because that, my lord, I have not received that 13 to notice. Besides that, he is not the
That is a general thing
defaulter.
in
He is
every
not a
case,
defaulter. For a moment, my lord, kindly see Annexure C, page 39, my lord. For a
All
moment,
that
is the
I'll be
bank
able to,
statement.
all that I'll be able to
No,
appreciate.
bank
provided
statement
the-
from the date of sanction the loan, my lord, kindly see, page 53 is the last.
Mr.
that
Counsel,
Till
I will
2025.
appreciate all these
Till
contentions.
25, he has regular in repayment, even in the
Provided
one
the
single,
bank is before this court.
even a single installment, he has not, these things not, because but that.
First of all, this writ petition is not maintainable. Still, the court is interested, is inclined to consider this writ petition, provided the bank is before this court.
Till that time, I will serve
No
the
till-
copy
no till such
personally.
time, no ex parte orders in this case.
Personally, for a moment, Lord, kindly see, till
I'll not-
January
I'll not do that.
2025.
As a matter of course, in none of the matters I'm interfering.
Till 25, 1st January till 25,
Then
he
go to
was
the
the regular,
DRT, so it's a
regular,
good
because
case.
thereafter his mother-in-law was not suffering.
No, go to DRT, where you have an option and a good case.
I am not denying that I will not pay that, only I am seeking some time, 2 months breathing
Who
time.
is the court to give you time?
Because
It
this
is, they have done the money, they have given you the
This
money.
court can exercise the jury, this
Will
discretion.
exercise the
depo-
jurisdiction
Discretion,
subject
because I am
to-
not asking more time, Lord, only seeking 2 weeks, 2 months time to pay this entire amount.
I
Some
can
breathing
do,
time is
that I
required.
can do, provided the bank is before the court. I will not exercise that kind of a
Till
jurisdiction.
that time, because there is a
No.
only residential house, Lord, the minor children and aged parents are there, Lord. If they are disposed, Lord, that they will virtually and
They
speak,
will
Lord.
not dispose,
For that
that's
reason
not
only.
what happening under section 14. They will take a symbolic portion of the
Lord,
property.
because they are personally came and they are trying to take the physical possession. That is the difficulty, Lord. Even that Saturday, Friday also, they came to that.
What is the outstanding amount?
That 44 lakhs, Lord. 40.
Pay 20 lakhs. Pay 20 lakhs and I'll grant order.
But
No blanket order.
condition, because for that 50%, 25%, I'll pay that 4 weeks or 8 weeks time. Maybe.
10%, 20%. Why should this court
Because
interfere
Lord,
in
he
the
is not
matters
a
of this
defaulter, Lord. He is
nature?
regular in repayment, Lord.
If there
The
is
kindly
a
see
regular in
annexure,
repayment, why will
annexure
they
C, Lord,
initiate
page
proceedings?
59, 39, annexure C, page 39, right
No
from
merits,
date of
Mr.
availing the
Counsel.
loan.
No merits. Option one, adjournment on the appearance of the respondents, I'll hear. Number two, pay 20 lakhs, then I'll pass it.
Some reasonable time may be given, Lord, because. with
What
re-
reasonable time?
That 4 weeks or 8 weeks.
No. Why you want 4 weeks? I will take up the matter day after tomorrow, provided you serve the notice.
Lord,
I'll
because
dispose it off.
they are, even today also they are threatening that they will come and dispose of this petition.
They will
That is
do
the
it, they will
difficulty.
do it, because
Even I
they are
mentioned in this
supposed to pay
my
the money.
memo for posting some conditional stay may be granted because for the aged and minor children are there, Lord. This is only the residential premises available for this petitioner.
But
to
you have
stay for.
mortgaged it.
Pardon, Lord.
But you have mortgaged it.
Mortgage is there, Lord. I am not denying that, and also I am not telling that I will not pay that. Only seeking some time,
In this
breathing
manner,
time.
interfering in this manner is a pure defeating the very purpose of the act.
Because for that
Not
some
necessary that
conditional
they should-
stay, because otherwise
Conditional stay will not be on peanuts.
I am not seeking more than 4 weeks, Lord. That only 1 month I am seeking to pay that, because the amount is also that huge amount, the 20 lakhs. That's why I am seeking for that 4 weeks time to pay
I will
that.
take up this matter day after tomorrow. Day after tomorrow, by the time you serve the personal notice on the bank.
Lord, that today they are going to do
Day after
dispose of.
then I will not pass any, I'll say, I'll take up this matter day after tomorrow. Till day after tomorrow,
Till that time not to precipitate. I will today itself.
And I'm making it very clear, on day after tomorrow, on terms, if you don't pay that whatever amount they say, I will vacate the order. On day after tomorrow, they'll take the steps.
Day after, Lord, kindly, within 2 days, it is not possible because the huge amount of 20 lakhs rupees.
You are
That's why I'm
waiting from
requesting.
When was the 13-2 notice?
13-2 notice I have given, stated that they have not served that. In my writ petition.
I record that also. In every case, this is the standard averment.
Because for that is the whatever is there. And also, Lord, I have stated in my petition, I have stated para 4 that.
Please wait.
I have held the loan of 44 lakhs. As and today, I paid that 15 lakhs, Lord. That in para 4, I have stated clearly, and also in support of that, I produced the bank statement, Annexure C, page 39.
And counsel for the petitioner submits that no notice is issued under section 13.2 or section 13.4. It is submitted that he has never defaulted in spite of their securitization proceedings or initiated. The petitioner shall serve the hand summons on the bank, on the respondent bank, and shall file a memo to that effect by 29th. List this matter on 30th. The respondent bank shall get instructions on on service of 13.2, 13.4, and about the fact that as asserted by the petitioner that the account has not become NPA. If either of the facts that are stated before this court are incorrect statements, then this court will impose costs of rupees 10 lakhs on the
But with regard to NPM, Lord, I produced the document statement from January 2025. He was regular.
You are asserting it. Please keep it your
regular. I am because I produced that bank statement.
The 13.2, 13.4, and the NPA. Any of the statements that are made before this court or in false statements, the writ petition shall be dismissed on exemplary costs of rupees 10 lakhs. Then the respondent bank shall not take any coercive steps till 30th. List this matter on 30th.
Much obliged.
And
whatever the amount I paid from the loan, I produced the bank statement. It is
I think
very
you are not
clear.
listening to what the court is saying. Whenever I'm asking, you're also keeping on arguing. How will you know what I'm asking? So please tell your client either 13.2, 13.4 or about this. Any of the statements are wrong, and that day you cannot make any. You can't request the court not to impose costs because that's what the statement you made. Once they come up with that and show that the notice is served on your client is going to pay 10 lakhs. Yes.
Because I have stated in my writ petition also for that reason.
Yes.
K.S. Ponnappa for petitioner. Till number 13.
I pay for the petitioner in this matter, my lords.
Yes.
I've challenged the order passed by the DRT directing the respondent number 2 to pay the rent payable to the petitioner to respondent number 1, my lords.
Why you can't go before the DRT? First question.
My lords, first, my lords, there is a statutory violation that has happened in the present.
What is the statutory violation?
The petitioner, my lords, had approached the.
Why that violation cannot be considered with the DRT?
DRT has become functus officio, my lords.
Why?
Because order is already passed in my absence. I have not been heard. I produced the order sheet also. Nowhere it says that I am on record in the proceedings.
You are against the order of the DRT.
Yes, my lords. My lords, there is a statutory violation because of which now I have approached this honorable court because this honorable court can exercise the discretionary jurisdiction. Only one submission that I'll have to make, my lords. The respondent number 1 bank was aware that I had approached the NCLT under section 94 of the code. Once I approached the NCLT under section 94 of the code, there is a moratorium which takes place and no debts can be acted upon by any of the parties until the NCLT decides on that matter. This order was communicated to the bank, and when the bank went to take a precipitative action and a similar writ petition was filed, this honorable court stayed the action of the bank. While that matter was pending, my lords, may kindly see what the bank has done. Instead of taking possession of the property, the bank goes and where the rent is payable to me by another bank, the bank goes and seeks the DRT's order to direct the respondent number 2 bank to pay rent to me. I'm only a guarantor. And the minute I file an application under section 94 of the IBC, there is a moratorium, my lords, because of which the bank in the first place could not have approached the DRT. And if it had approached the DRT, it had to communicate that there was an insolvency proceedings which was underway. And it was not only that I have filed an insolvency proceedings on my own. The bank also filed an application under section 95. So the minute the bank files an application under 95, There is a
What
moratorium.
happened to the earlier writ petition?
That's pending consideration before this court. A list of authorities has been filed and it has been listed for final orders. And there also, my lords, there is an interim order which is operating as on date,
Which year is the writ petition?
2024, my lords.
So it will go on like this, 24, 25.
No, my lords,
is
I
the
have
writ
produced the
petition?
order sheet. I have not taken time in that matter. I
We'll have
filed.
26 writ petition, all tagged on, we'll hear it in 29.
No, my lords, that is coming up before my lords.
When is it coming? Who is appearing for the respondent in that? The
My lords,
matter?
Learned Counsel Vignesh Shetty appears.
Yeah, where is Mr.? Yes.
Copy may be served, my lord, I've taken.
Serve the copy on him.
I've served a copy.
So and so is directed to take, Mr. Vignesh Shetty is directed to take notice on behalf of the respondents.
Number one, my lords.
Respondent number one, who is the other respondent?
I'm not aware of the council appearing. for
Bank
this
of
matter.
Baroda, who appears for Bank of
I
Baroda?
can take notice for
Huh?
that. I can take notice.
I
I will take notice.
But there's
For
a
one and two.
conflict. my lords.
Conflict, then I may.
There is a conflict because respondent number
Who
two
is
has
the
been.
other counsel?
Nagaraj Damodar.
Huh?
Mr. Nagaraj Damodar.
So write on the paper, so and so is directed to
Bank
take
of
notice.
Baroda.
When is the other matter coming up?
My lords, it's coming up on 18th of November, my lords.
18th November.
18th of November.
We'll hear this also on that day.
Please, my lords, let there be an interim order till that date, my lords.
What is the interim
The
order?
interim order is only to restrain the respondent number one to pay the rent to the respondent number one.
Get instructions, we'll
My lord,
take
I'll
up.
take instruction, my lord. Have it tomorrow.
Day after tomorrow,
My
doesn't
lords, one
matter.
submission, my lords. The only reason is the order was passed on 25th of August. Till date, they have not pressed the order into operation, and I was also kept in the dark. It was only yesterday that
This
was,
doesn't matter. This is matter day after tomorrow.
my
By
request
the
for
time then
31st,
counts
my
for the
lords.
respondent shall get instruction.
My request for 31st.
Yes, 31st.
Grateful.
Friday is not, it is not possible. Either it is 30th or on 3rd.
I'll
Which-
request for third, my lords.
3rd.
Grateful.
Yes.
Preliminary hearing big group, cell number 14.
In this case-
Prasad for petitioner B.S. Mahendra.
In this case, appearing for petitioner, my lordship. My lordship, in this case, order dated 11/3/2024, my lordship. They challenge the section 14 order, my lordship.
You appear for the petition or respondent?
For the respondent, my lordship, bank, my lordship. My lordship, the honorable court has,
That the petitioner would deposit 10 lakhs to the bank towards the loan, which is now closed to rupees 32 lakhs. According to the, in the event petitioner would deposit 10 lakhs, the bank shall restore portion. Has he paid?
they no complied the interim order, my lordship.
No representation on behalf of the petitioner. Counsel for the respondent is present. This is matter for dismissal on November 12th.
Cell number 15.
Grateful, ma'am.
Divya A. Jain for petitioner.
It's a matter where, my lord, the auction purchaser, my lord, approached this.
Why have you not complied with the objections raised with the office on statement of objections?
Lord, I'll comply, my lord, during the course of the day.
Each page has to be signed by the council.
Let it-
Where is the council for the petition? Any interim order in this?
No, interim order is not there. What had happened, my lord? The sale, my lord, petitioner is the auction purchaser. He purchased the property, my lord, pursuant to my lord auction notice I issued. Thereafter, my lord, the borrower approached the DRT. DRT, my lord, set aside the sale. And my lord, there's a direction for me to, my lord, refund the money to the auction purchaser. My lord, subsequent to this, my lord, kindly come to page number 36. Paragraph number 2.
Then what happened?
My lord, there's a direction for me to, my lord, hand over the entire money that, my lord, which is paid by the auction purchaser, along with 6% interest, which I did it. My lord, nothing survived for consideration in this matter.
You will have it tomorrow for dismissal.
Grateful.
This is matter tomorrow for dismissal, no representation for the petitioner. Yes, next
Cell
16.
number 16. Cell number 16. K. Ravishankar
Last
for
occasion, they
petitioner.
sought time to
appear
file
for-
objections.
Please, my lord, I seek for, it's 1 week's time, my lord. We have sought for instructions because the contention is that additional.
Why, no, because your matters are listed in the list. Other matters are out of the list. Why do you just like that seek time? On 17/10/2025, you sought time.
Please, subsequently, we have sought for instructions. They are demarcating to the effect that which has been taken into possession, my lord, and the other documents are on the, kindly 1 week's time, my lord. In 1 week's time, we'll place our objections. on
We will
record.
not grant 1 week time. This is matter on 26th of November, in spite of the time granted. Again, the land council for the respondent is seeking time. Interim order is there.
No, no, there is no interim.
This is
It's
matter on.
Livestock, say, last ships have said 26/11.
uh,
Can it be before that? It's a 1 month's time. Is
19th November.
Cell
Yes.
number 17. A. Nagarajappa for petitioner. Divya Purandar.
Hearing for the respondent.
My lord, I am challenging the sale notice, my lord, in this, my lord. My lord, page number 65, my lord, may kindly be seen, my lord. My lord,
Why should the sale notice be interfered?
my lord, here, my lord, earlier, my lord, the petitioners, my lord, have filed a writ petition, my lord, and my lord, interim order was granted, my lord, subject to the deposit of 7,50,000, my lord, within 3 weeks, my lord. Within 3 weeks, my lord, the petitioners has deposited the 5 lakh rupees, my lord. Due to the financial crisis, my lord, he couldn't deposit
What
in
is
time.
outstanding
Later on,
amount?
My lord, 1 crore. My lord, they have not deposited within 3 weeks. They in fact deposited.
Anyhow, 1 crore is the outstanding.
Yes, my lord. There are two accounts, my lord. They are only referring to one housing loan account. In fact, there is an OD account and both the properties are separate and both have been combined in one sale notice and total outstanding, my lord, from the same customer is 1 crore, my lord. Around 1 crore as on 30/9/2025.
Yes.
my lord, here, my lord,
Why should we interfere with the sale notice? Please tell me one legal ground.
my lord, here, my lord, I
Only
have
on
paid,
legal ground we will interfere.
my lord,
What
they-
about a rear court, granting interim order, paying, not paying? This court is not concerned. Now you are questioning the sale notice. Why should this court interfere with the sale notice?
my lord, I need some time, my lord, we'll pay it, my lord. My lord, they have added some
Already you
interest
are,
on.
you have asked 1 crore amount.
My lord, not a 1 crore, my lord, they have added an interest and it has been become a 1 crore, my lord. Actually, my lord, 27 lakh 58,000 should be paid by the petitioners, my lord.
Then now all these disputed facts, this court cannot decide. Go before the DRT. Say that what is the amount you are supposed to pay. According to them, it is 1 crore. According to you, it is 22. How can this court go into those disputed questions of fact?
Yeah, my lord, and the date has been fixed for auction, my lord. It has
Let
been
it be,
fixed
go
for
to the
30th,
DRT
my
and
lord.
get it decide. Now this practice we should stop. Just like that, we can't stop the auction proceedings without any basis. You please show one legal ground why this court should interfere. This court will interfere.
My lord, earlier, my lord, as per the interim order, my lord, I have paid 7
Forget
lakh
about the
50,000 and
earlier interim
apart
order.
from that, I have paid extra for 4 lakh 55,000, my lord. In spite of that, my lord, the sale
They're
notice
only
has been
concerned
issued.
with the sale notice. Outstanding is 1 crore according to them. And if you're ready to pay that 1 crore amount for some, whatever the time and all you're seeking, then we will at least consider that. But not they saying 1 crore, you saying 20 lakhs. This court can't consider all that. You will get an opportunity before the DRT, go before the DRT.
My lord, interim order may be granted, my lord. Till then, my lord, is subject to some payments, my lord, will make it, my lord, now.
When you have a liberty to go to DRT, why don't you go to DRT? Why should there be a direction subject to?
Because within 3 days, my lord, that is 30th, my lord, the auction date has been fixed, my lord.
When are the 13-2 proceedings? Notice is issued when?
Is in the year
22.
2000.
When was the earlier petition interim order is granted?
Earlier in
10/9/2024.
What are you doing from 10/9/24 till now?
My lord, I have paid the amount, my lord.
What happened to that writ petition?
No, that is
It's
still pending,
still
my lord.
pending consideration,
That is
my
still
lord.
pending. In fact, they were asked to pay 7 lakhs within 3 weeks. They have not paid within 3 weeks. So we filed a memo
But
that it is
later
not
on-
complied and we proceeded further.
Later on, we have paid
Thereafter,
7 lakh
this
50,000.
year they have paid because we issued sale notice.
But
What is
apart
that
from
writ
7
petition
lakh
number?
50,000, I have
Hello,
paid
writ
for.
petition number is 24.
We'll hear both. Take along with, give the number. List
2429.
along with.
24920.
Number so and so on 4th of November.
Grateful.
Yes, next matter.
List number
My lord,
3.
till then, my lord, in auction, my lord,
Let it go.
date has been fixed, my lord.
List number
My lord.
3.
Sorry for interrupt, my lord.
Orders.
Sorry for interrupt. List number 2, serial number 10, my lord. In submission. List number 2, serial number 10, passed over matter. They want to submit.
Why you people only call the matter when it has to be taken up?
No, my lord. Sorry for the interruption.
We will see in the afternoon, not now. Yes.
Serial number 3. List number 3. Serial number 1. For orders matter, Raghavendra KN for petitioners.
I appear for the respondent, my lord. This is a matter where,
Who is the petitioner?
no, they have obtained stay and they have not complied with the office objection. My application is not being listed. There is a delay of 935 days.
List this matter for dismissal tomorrow. No representation on behalf of the petitioner. Counsel for the respondent is present. Next two.
Serial number 2.
Petition is yes, your lordship. 81 days of delays from filing. 81 days delay, your lordship.
Notice.
Serial number 3.
I appear for the petitioner, my lord. This is an ex parte order. The respondent claiming to be the wife of the petitioner, my lord, filed a case seeking maintenance of rupees 25,000 from the
Why did you
petitioner.
not appear before the court?
The Shara shows that he has refused, But my client says that my lord, he has not received the notice itself.
He will say, that's, in every case,
And I
that's what
don't
they
know
say.
where,
But now at this stage,
after only receiving the came to know that the FAW is issued, my lord.
if you want stay, on condition.
One submission, my lord. She is already married, my lord. She lost her husband and she had a son. And the husband, the deceased husband is the petitioner's
What is
friend, my
granted
lord.
is 3,000 rupees. For that, we
No.
have to grant a stay.
And the question of paying the amount does not arise, my lord.
If
She is
that is
not
the
the
case-
wife at all, my lord.
At this stage, in an ex parte order, we will not consider about the legality of the order now.
No, it has to be
Notice.
remanded, my lord.
Notice to the respondent, will not grant any stay in this. Notice to the
Otherwise,
respondent.
FLW will be issued, my lord.
Yes, for.
May seek stay, my lord, subject
On
to some
condition.
condition.
Some condition is 3,000 rupees, 50% of the amount to be deposited. Within, we will not, let there not be an order for withdrawal.
Please.
But you should deposit.
Please.
It is submitted that there is no relationship between the petitioner and the respondent. As per the Shara, it shows it is refused, and that's how the petition is set ex parte. But no notice is served on the petitioner according to him. It is submitted that he has no obligation to pay as she is not the wife, considering all and it is submitted that no, the FLW is issued, considering the same, there shall be stay of all further proceedings on the condition that 50% of the amount at 3,000 shall be deposited within a period of 4 weeks from the date of receipt of the copy of the order. Notice to the respondents. Please, yes, next.
Cell number 4, for admission.
I'm for the petitioner, my lord.
Huh? Before the family court. Yes, for.
I'm for the petitioner, my
There
lord.
is arrears of 2 months, my lord. Last occasion, we have mentioned that.
Please argue the main matter.
My lord, that there is a settlement.
Every time this is a mentioning you are making, every time this is what is happening. Let's see the cost title. What did you say earlier?
No, my lord. The child is wanted to be with the father. That's why only kindly refer to the mediation, my lord.
We are ready, my lord, but positively they have to reside, my lord. She is
We will
respond mother is also present before
Both the parties shall appear before the where?
Bangalore mediation.
Okay.
For the Bangalore Mediation Center on 6th of November.
Please, my lord.
On 6th of November.
Please, my lord.
Much obliged.
Yes, list this matter after the report is received.
Cell number 5. Cell number 5 adjourned. Cell number 6. N. Jagadish Balika.
The husband is before the chief. Earlier 1,000 has been granted to the wife. Now after in the modification order, it has been enhanced to 4,000.
What is your income?
Income is now I am producing the bank statement. I am a retired employee. I am
But you can
getting
tell the court what is the income.
2,633 rupees I am getting as a pension. Other than that, I don't have any.
Let's see the order. The court must have recorded reasons for that. What is the age of the petitioner?
The age of the petitioner is 68 years.
Earlier, what is the amount he is paying?
1,000 rupees till end of December 2023 he paid.
The court has passed an order whereby the maintenance of 4,000 is granted to the wife. When council submits that.
From enhanced from 1,000 to.
It is submitted that the maintenance is enhanced from 1,000 to 4,000. The petition is not in a position to pay the said amount. Considering the same, considering the submission, there shall be stay of all further proceedings on the condition that the petitioner shall pay an amount of rupees 2,000 per month and the arrears also at 2,000. If any.
He already deposited, he already paid 14,000.
I said if any.
Please.
Within a period of 4 weeks, notice to the respondent.
Cell number 7. Kishan GS.
For appellant, my lord. Lord, inadvertently I had missed out to file application for stay of the impugned judgment, my lord. May I request this honorable court to take up this application?
They file it in the registry.
Kindly have this day after tomorrow, my lord, because arrest warrant.
Day after tomorrow.
Great.
Cell number 8.
This is
final
matter
hearing.
day after tomorrow at the request of the land council. Yes.
8, final hearing. Venkatesh Somareddy for petitioner. Ramesh.
Serial number 8, my lords, may I request that the matter be referred to mediation, my lords. For this reason, my lords, please, my lords. Between mother and son, my lords, 10,000 has been granted, my lords. Maintenance.
Non-filing of acknowledgement for having deposited 50% of the maintenance amount by the order dated 19/3/2024,
Yes, because
18/7.
interim order has been vacated, my lords, therefore I'm requesting that if we could sit together, sit and.
At the request of learned
Please.
counsel, the petitioner lists this matter on 27. Where is the other side? Whether there is any scope for
I have spoken to him. I will speak to him now. Maybe past or minutes, I will speak
ask
to him.
him to come.
Please, please.
Because there is no purpose in sending the matters to mediation.
Please.
And there is no interest for the parties. Yes, next.
Serial number 1 for orders BC Shivanne Gowda. Awaiting service of notice.
List after service of notice.
Serial number 2 disposed. Serial number 3. Serial number 3.
For appellant, my lords, we have deposited, my lordship, on.
I will deposit the amount.
Please, we have deposited, my lordship.
Learned counsel for the appellant submits that the amount is deposited before the trial court. Notice to the respondents.
Seeking stay, my lord. Insurance company challenging on the ground of liability. No relationship between employer and employee, my lord. As of
It is submitted that the insurance company is before this court questioning the liability. There shall be stay on the condition depositing 50% of the amount.
we have deposited already entire award amount along with interest, not to disperse deposited amount.
No, it is submitted that there shall be a stay as it is submitted that the entire amount is deposited. Yes.
Please, my lord.
Serial number 4. H. Pawan Chandra Shetty. Serial number 4.
No representation for dismissal on 12th of November 5.
Serial number 5. Narasimha Prasad SD.
Cross objection is filed. There appears to be some office objection. I shall
Office
comply.
objection shall be complied with within a week.
Please.
Default order. 6.
Serial number 6.
I number 1025 is filed.
Waiting for respondent.
So and so. Yes. 7.
Number 7. Serial number 7. Oriental Insurance Company.
Oriental Insurance. There is a new list is given.
Application. New list is
No, the legal service authority also I told. Call Raghu. Why he has not got the list.
yes. Serial number 7. Suma for petitioner. Notice has to go. ma'am.
Oriental Insurance is which?
Oriental is the petitioner or appellant only. Insurance company.
No, it is insurance company.
Yes, ma'am.
Notice to the respondent.
Serial number 8.
I number 1025 for substituted service of paper publication to respondent number 1. So and so.
10 11.
Hmm.
25 11.
Next.
Serial number 9.
I number 1025 is filed to condemn the delay of 53 days in filing.
No, they have not yet served copy, my lords. As per court order.
They have not served.
Served.
No representation for the appellant. This is matter for dismissal. Give some date next week. Yes.
31st.
What about this?
Serial number 10.
For appellant Billard.
Which is the respondent insurance company.
R2 Sriram General.
Mr. B. Pradeep is directed to take notice on behalf of the insurance company. Liability is on whom?
It is only insurance people only.
Then who is the other respondent?
R1.
R1.
File a dispense with memo.
Please, ma'am.
The memo is, write it and give.
Okay.
A memo is filed seeking dispensation of notice to R1, dispensed with. I number 102, I think there is a delay of 2926 days.
Please, ma'am.
The 2,900
I will file necessary objection, my lord, for delay.
For filing objections, let's just matter after 2 weeks.
Please, my lord.
Yes, 11.
11.
8 may be given.
It will come. Yes, 11.
11.
Which is the respondent?
Anand Kumar. R2 is Oriental Insurance Company. R1 is a private. Oriental Insurance. R2.
Mr. Janardhan Reddy is directed to take notice on behalf of the respondent insurance company. Notice to R1, 12.
Serial number 12.
Same in all this appellant shall serve the copy. Yes.
R1 Tata AG. R2 private.
I'm applying for appellant.
R2 dispenser.
Memo is for seeking dispensation of notice to R2. R1 is?
R1 is Tata Elxsi.
Mr. Lingaraju HS is directed to take notice on behalf of the insurance company. I number one of 20. This is 11 or 12?
This is A1 of 25.
12. I number 1 or 25 is not pressed since the appeal is on time. I1 is 1 of 25 dismissed as not pressed. Admit post for final hearing. Call for the TCR.
Cell number 13. 13. R1 if court of view.
Why this IA2 of 25
Kevin
to be
Nayak.
allowed?
Kevin,
Tokyo.
Tokyo, R1.
Mr. E.S. Sanmati is directed to take notice on behalf of the respondent insurance company. Notice to the respondent.
2.
Next.
Cell number 14. R2 is if court of view.
Mr. D. Vijay Kumar is directed to take notice on behalf of the insurance company. Memo is filed seeking dispensation of notice to R1 dispensed with. I have 1/25 to condone the delay of 43 days condone. Admit post of final hearing in all the matters wherever I say notice so and so, the appellant shall serve the copy. It's 15.
16. Cell number 15.
I number memo is filed seeking dispensation of notice to R1. Who is R2?
R2 is HDFC Ergo.
Mr. D. B. Pradeep is directed to take notice on behalf of the insurance company. Memo is filed seeking dispensation of notice to R1 dispensed with. I number 1/25 to condone the delay of 58 days condone. Admit post for final hearing. Call for the TCR 16.
Cell number 16. Sanat Kumar KM. R2 if court of view.
R2?
Court of view.
Who else appears for IFCO Tokyo?
If court of view. B. Pradeep.
No, who else? Other councils?
Others.
PS Jagdish.
Huh?
PS Jagdish.
PS Jagdish is directed to take notice on behalf of the insurance company. Notice to respondent number 1 or 2?
R2.
No. R2 is private party.
R2 is a insurance company.
That's what I'm saying. R1, notice to R1. Yes.
Cell number 17. D. Vijay Kumar.
No representation. List this matter after on 12th of November. Yes, 18.
Cell number 18. Venkatesh.
Petitioner, my lord.
Cell number 18. All private.
Another connected matter is there. That is 2305 of 22.
List along with so and so.
Owner, this is the owner of
List to
it.
the respondents.
Cell
Yes,
number
19.
19.
And one submission, my lord. Execution petition has been filed and regarding attachment warrant has been issued trial court.
1,615 days. We will not consider this now. Yes, next. 19.
Cell number 19. Venkatesh Kamat. A petitioner all private persons.
Notice.
Cell number 20. Insurance company appeal.
Insurance company, I'm challenging on the ground of quantum. I'm filing dispensation, respond number 2 of the owner of the vehicle. I'm filing
Memo is filed seeking
dispensation.
dispensation of notice to R2.
Case, please, my lord.
Dispense with you on what ground?
I am on ground quantum, my lord. Case of injury. Age
How
hours,
much is granted?
is granted 17,51,971 rupees.
According to you, how much it should be?
According to me, my lordship, as per disability, my lordship is minor, my lord,
How
16
much
years.
is?
I am liable 7 lakh. I will deposit, my lordship.
Not even half of the amount.
Actually, my lordship, in this loss of income, future loss of income, 7,92,000 rupees has been awarded. Then, my lordship, non-pecuniary damages, 5 lakh again they have granted.
The land council, for the insurance company submits the insurance companies on the question of quantum. And it is submitted that the court has granted exorbitant amount of 17,51,917. There shall be stay of all further proceedings on the condition that the you deposit entire amount
My lord,
on the
this,
condition that they shall deposit 50% of the amount and the respondent is at liberty to withdraw an amount of rupees 7 lakhs. Yes, next.
please, my lord.
Notice to respondents.
Final hearing matter, cell number 21, Gopal Krishna N. For appellant, Somsekhar KM, Manjula N. Tejasvi for R2.
Pass over. Next 22.
Cell number 22, Ash Shashidhara for appellant,
Oriental Insurance Company who appear?
Oriental.
Mr. Ashok and Patil is directed to take notice on behalf of the insurance company. Counsel for the appellant shall serve the copy. Give list of matter on 12th. S23.
Cell number 23,
If court okay, you who appears? You-
if court.
Shivanegoda BP. BC Shivanegoda.
Huh?
BC Shivanegoda.
Shivanagora is directed to take notice on behalf of the insurance company. Counsel for the appellant shall serve the copy of the appeal memo. This also on 11th of November. 24.
Cell number 24. 24, Rangegowda NR.
Liberty General Insurance who appears? You appear. Pradeep is directed to take notice on behalf of R1. Counsel for the appellant shall serve the copy of the appeal memo. Listed on 13th of November for 25.
Cell number 25,
Where is he?
KB Nayak.
Pass over,
Pass
let
over.
him come. Yes.
Cell number 26,
I am for
Oriental-
appellate, my lord.
General
Oriental.
Insurance to appear.
Syed Abdul Sabur.
Yes, appellate, appellate, my.
Mr. C. Ravishankar. C.R. Ravishankar is directed to take notice on behalf of the respondent insurance company. Then counsel shall serve the copy of the appeal memo on the counsel listed on 18th of November. Yes, 27.
Number 27, D. Vijay Kumar.
No representation. List the matter on 10th of December. Yes, 28.
Number 28,
Yes, Gurudev Prasad.
Uddhav Prasad.
Pass over. 29.
Cell number
I am
29,
appellate in this case, my lord.
Cholamandala who appears?
Syed Abdul Sabur.
Cholamandala.
I am appellate.
You appear. Mr. B. Pradeep is directed to take notice on behalf of the R2 Insurance Company. Same, serve the papers, list the matter on 20th of November. 30th,
30,
Mr. Betsur, where is,
Sunkapur.
you ready?
Yes, my lord. Quantum Miller only.
Pass over.
Announcement.
Inform him, Mr. Betsur.
Please.
Yes, 31.
Cell number 31,
The branch manager, what is this Chola MS General Insurance Company? That is Cholamandala only. Yes, Miss. Apart from you, who are there for Cholamandala?
HS Lingaraj.
Huh?
HS Lingaraj.
Mr. H.S. Lingaraj is directed to take notice on behalf of the respondent insurance company and then the counsel for the appellant. She sell the copy of the appeal memo. Lists the matter on 27th of November. Yes, 32.
32,
I have for
D.
respondent.
Ravishankar Shastri.
Next week, Lordship.
My lord. I'm for the appellant, my lord.
You're ready?
Yes.
You don't have papers?
I have next charge as well. After this.
It's a case of death or injury. We can look at our papers, we'll see. Yes.
Appellant is the daughter of deceased.
Now, what is the, let's see come to the table.
Table is, Lordship,
What is the age of the deceased?
53.
page number 23. Judgment. You have taken fitness
Anita.
certificate, but negative.
What
That is
you
the
do
only.
is every day, remove these papers. I don't want these papers. I don't want the papers. Yes.
Page number 23 of the
Age
judgment.
is?
23.
Huh?
23.
23
Chart is
years.
there.
23 years. Court had taken the income?
Income at Lordship.
14,000 per month.
14,000.
Notional income, ma'am.
Which year is the accident?
2019.
2019, rightly taken.
Rightly taken.
Ma'am, but I have one submission. He was a headmaster in Saint Patrick English Medium School. Before that, he was working in Gujarat as a social science teacher, and he was earning salary of 26,500.
23 years, already working as a lecturer, already working as a headmaster by the age of 23, 23. How can it be?
He has completed 21, he has become a headmaster.
Headmaster, he has become-
He's a principal and he's an that one, so on, so on.
He was aged.
Let's see what's the age of the deceased.
'53.
I think you read it, is 53 it seems, not 23.
Yes, 53. Yes, Your Lordship, 53. But.
What is the evidence
multiple
adduced by
11.
you?
Exhibit P9 is the.
1 minute, let's see. True copy of the spot Mahajar, true copy of the motor vehicle accident.
Exhibit P9 is the
Postgraduate
BA
diploma, BA certificate of the deceased.
P10 is
Postgraduate certificate, degree certificate, appointment letter. Give exhibit P12, P13, and P15, 16.
Only one claimant as the dependents.
Let's see.
Daughter.
Letter of appointment with general terms and conditions dated 29/8/2011. In June with the response, we discussed them with the earlier appointment. Revision period. Salary as on 2011 is rupees 17,140. What is this? I'm not able to understand. GD Goenka International School dated 29/8/2011.
Yes, my lord.
It is speaking about basic pay 17,000, special allowance
10,000.
7,000. So it's coming to
6,500.
25,000 per month.
Yes,
Then this is Bank of Baroda.
yes, my lord.
Working in this institution as headmaster from January 2019 to May. He was drawing monthly salary of
15,000.
why his salary has come down from 2011 25,000.
Because he shifted from Gujarat to Mangalore because of her child, because his wife was predeceased in 2014. That's why he resigned his job in Gujarat.
So
and-
according to you, it has to be taken at 15,000.
Yes.
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 We'll take it. He's a qualified person. What 15,000 they're seeking is in fact on the lesser side.
15,000.
That's what you want.
Yes.
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 And 50% has to be because.
What the court has done.
Daughter,
50%.
50% only. That's
But it should be taken as 1/3 because.
daughter is only 25 years.
Yes,
Mother,
my
there is
lord.
the dependency.
When this incident was occurred, she was studying in second year degree, and as per the Sarala Verma's case, file number 30.
Wife, correct. But this is daughter.
Yes.
50% is
but-
right. There is no question of 1/3.
But
2 to 3, it is 1/3.
yes,
If it is 5, we are considering it as 1/3.
but even she is now orphaned, and no one is ready
always.
to take care of her.
So 15,000. Future prospects, how much?
See, 53 years.
10% or 25%?
53 years.
10%.
10%.
10%.
What is the multiplier?
11.
11. Kindly give the trial court whether I am satisfied because no, we have taken a
Give him the
fitness-
record. Take this.
ರೆಕಾರ್ಡ್ ಮೇಡಮ್ ರೆಕಾರ್ಡ್ ಕೊಡಿ
Record.
ಅದಕ್ಕೆ ಕೇಳಿ ಕೊಡಿ ಅಂತ ಹೇಳಿದ್ದು.
What do you want? Very small difference. It was 12,13,560.
Yes,
Now with this calculation, it's coming to 12,81,460.
Yes, sir.
Ma'am, 50%.
Huh?
That must be taken as 1/3. ma'am.
Documents and.
Because
interest is.
she was dependent
No,
fully
that's
on
fine. If it is as per Sarna only, one to the 2 to 3, it is 1/3.
Yes, ma'am.
She is the only dependent. Please come. Agreed with the award passed in. MSC number 1532 of 2019. Dated 20th February 2025. The claimant is before this court seeking enhancement of the compensation. The tribunal has granted the compensation as per the table given below at page number, paragraph number 25. Learned counsel appearing for the petitioner submits that while before the death, the deceased was working and drawing an income of 15,000. But the court had taken the notional income at 14,000 and 1/3 has been deducted. 150% has been deducted. It should have been 1/3 on all these and on the conventional health also. The amount that is awarded by the tribunal needs to be enhanced. Learned counsel appearing for the respondent insurance company submits that court has rightly deducted 1/3 has deducted 50% as the 50% as. I think when in case of wife, it's only when one the dependent also, I am considering 1/3. Why not in this case?
Because the daughter is because 25 years.
50% we were taking.
50% has to be
50% we are taking in case of minor.
minor, correct.
I mean, not minor. In
Allah,
case of
bachelor.
Bachelor.
Yes.
Remaining all cases, I have granted so far granting 1/3.
Correct, Your
Even
Lordship.
if it is wife also. Wife is also one only.
But is it daughter, correct, Your Lordship, daughter, because automatically she has married and some good.
Then she married. As on the date, what is her
That
age?
is not come out
19
before
years.
this one.
19 years.
She is not married.
Allah, it is not in the time of petition. After that, she married and that's why 50% has to be deducted by the tribunal, rightly.
She's not married still now, my lord.
There is no.
9% ಇದೆ. ಇದೆಯಾ ಅಂತ ಇದು ಜಡ್ಜ್ಮೆಂಟ್. ಇದರಲ್ಲಿ MF ಕಂಪ್ನಿಯವ್ರು ಅಪೀಲ್ ಪ್ರಿಫರ್ ಮಾಡಿದೆ ನೋಡಿ ಮೇಡಮ್. ಮೇಡಮ್ ಕಂಪ್ನಿಯವ್ರ ಅಪೀಲ್ ಇದೆಯಾ ನೋಡಿ. 1939, 1532.
What did you write? Deducted 50%. And there are no grounds seeking enhancement of the compensation. Having heard the counsels on either side, there is the material on record. As per the evidence on record, she's working in a school and earning 15,000 per month. The certificates are also filed to show the qualification. For the year 2019, as per the table, as a notional income, it is 14,000. In these circumstances, as she is an educated person, this court is inclined to take the income at 15,000. Plus, as his age about, the deceased is 53 years old, 10% future prospects would come to 1,500, that is 16,500. This court finds force in the argument of the learned counsel of the petitioner, as her daughter is a dependent, and as on the date the accident has taken place, she is 19. This court is inclined to deduct 1/3 of the amount, that comes to 5,500. Then the income to the family, in the contribution to the family would be 11,000 into 12 into 11. Loss of dependency would come to 14,52,000. 52,000. The loss of consortium 44. Funeral expenses 36,000. Medical expenses as granted by the court 1,02,460. In the light of the law laid down in Mekala versus so and so, 10,000. Altogether, the claimant is entitled for an amount of rupees 16,44,460. Accordingly, the appeal of the claimant is partly allowed by enhancing the compensation from 12,13,560 to 16,44,460. Yes.
Cell number 33.
My appeal is there, not that switch. Because fitness certificate is negative, but we have filed the application for the my appeal anyhow, because 25 the judgment has been rendered. That's whether company has preferred an appeal or not. That's why checked and.
By the time your company should have given you the information about
They are not informed you, that's why I'm otherwise. Check ಮಾಡಿದ್ರೆ otherwise.
The number will list it.
I don't know the number. That's whether they filed or not. That's why I'm not seeking that one. Check it up and whether say no issue. Like if we not filed, you will not filed. That's it.
List this matter tomorrow under the same caption. Keep this yes.
That's all.
Yes, 33.
I will also check it up and inform the.
Happy for
Malad, it is the Malad, it is only simple enhancement on limited ground, so it can be disposed of. I filed an IA for return of trial court record. They satisfied the award. Malad, it may be disposed of if my lord permits, Malad.
Yes, what is that simple enhancement?
My lord, the date of accident is 28/1/2022.
It's a case of death or injury.
Injury. Malad,
please come to the table. Come to the table at page
yes,
number 21.
Yes, Malad. Pain and suffering 25,000 is a fracture of right, both the bones of right leg with biomalleable fracture of ankle, Malad. So there is a 3 bone fracture.
Pain and suffering.
Another 15,000.
No, one fracture we are granting 40,000.
But in the judgment, there no mention of injuries sustained by the petitioner. Nowhere it has been mentioned.
Why it is not mentioned? Without mentioning the injuries, we'll have the record. We'll look at the injuries. I'll look at the injuries. What are the injuries?
I'll go through one second.
Court must have recorded. Without recording, how will they?
Today morning.
Except pain and suffering, remaining aids are just and reasonable.
So pain and suffering, that's what I'm saying. We'll grant 50,000. Total 50, I'm saying, not enhanced 50. 50.
Well, a loss of immunity is 15,000 as a 15% disability. Well, what happened in this case is that the doctor has applied this
How many
telescopic
days you were in hospital?
6 days.
Well, he
madam.
was in 6
Again, by
days.
25,000, we will reduce this to 6,000. Then we will increase amenities. It will become one and the same. For 6 days hospitalization, how can there be 25,000
Well, he
towards,
has, well, not the days, my lord. He underwent surgery. Line of treatment is to be looked into, and further he required another surgery for removal of implant.
No, that
So,
is a different aspect that we will go. As far as the incidental expenses are concerned, we are granting like basing on the days he was hospitalized, we are granting. If he's for 6 days, why it should be 25,000? So that is already there, and 19,000 is extra here. Then loss of income during the later period, any claim on this?
normal.
Then it is not there. Loss of future earning capacity. What is it?
My lord,
65,000?
as far as the loss of future earning is concerned, only my request is, my lord, since the doctor has assessed the disability by adopting the telescopic formula, my lord, the reducing and said, my lord, as far as due to this 15% injury sustained, my lord, the 15% disability, as doctor said, reduce it to 5%. My lord, it may not.
No, 15% to the limb. That's what they
Not limb. Well, after adopting the telescopic formula, well, telescopic formula is adopted, A plus B, that is the formula is adopted to assess the whole body disability. I don't know how this method is adopted anyway.
According to the doctor, 15% to the
No,
limb.
what is this telescopic method of assessment?
Telescopic, it doesn't apply.
Yes, Pradeep, what is it?
Well, three limbs.
The mobility component, stability component all together, they have to calculate.
No,
If
it
that
comes
is
to
calculated,
the whole body.
if the whole body comes, not no 15%, it will reduce.
No.
One
Yes,
minute,
my
Mr.
lord.
Shastri.
I will-
one
I will-
minute.
I will
No,
give
no,
that
what I'm
circular.
saying is, on this telescopic method, once they do the assessment and give a particular.
That is the particular limb disability. Afterwards, whole body disability has to be
But there also you will get limb and.
Yes, my lord.
Whole body.
No. My lord, after assessing the limb disability, that is lower limb disability and upper limb disability, and lower this point and upper point disability, A plus B. Well, that into bracket 90 minus A.
Take the doctor's evidence.
Well, it is only my endeavor, my lord. I searched in the Google also. But when these telescopic formula is adopted, but before this adopting the telescopic formula,
Let us read the evidence of the doctor.
Yes,
That will clinch the issue.
PW2.
higher value minus lower value, that is 30%, 30%.
Court Commissioner.
CW1.
CW1.
In this case, disability certificate is also produced. Disability certificate also.
We'll see.
Madam Vincent Mohan, Doctor Vincent Mohan. Silva. Pro Commissioner.
CW1.
CW1, Vincent.
It is in Kannada, my lord. It is in Kannada. Repeatedly, I am requesting, my lord, that it is only my endeavor. How these after adopting these telescopic formula, again reducing the one-third.
It is also now the endeavor of the court to understand your submission.
Well, disability certificate may kindly be seen. Adopted, my lord. Disability certificate may kindly be seen. Disability certificate may kindly be seen.
Evidence of the doctor evidence.
Disability certificate may kindly be seen.
Well, let me see. Figures will be
No, more than that, disability certificate issued by the doctor, that is to be looked into.
Let's see that. That is exhibit.
That is
Let's see that.
Disability certificate.
Only 3 documents.
No.
Mobility
Disability
component.
certificate is produced.
C1.
That's what
I'm looking
mobility,
at it.
stability.
Knee flexion,
Yes.
hip, ankle, power, stability component.
Yes.
Total 29%. So is it 8.7%?
Yes, 1/3 is at, out of 29%, 1/3 is
Then
already deducted.
disability, A plus B, 8.7 plus 7.5 divided by 90 is equal to 15.4. That is less than 15%. Total physical disability for right leg is 15%.
That's what.
Said so.
Madam,
Right
that is
leg.
correct. That is no. Just I want to convince my lord regarding these 15% disability is assessed by adopting the multiplier method. Why once this method is adopted, that is due to right leg disability.
I'll do one thing. I'll record all your contentions and I will set aside this award and remand it. You please examine the doctor and elicit whether this 15% is to the whole body or to the limb. Because it is very clear. Total physical disability for right leg is 50%, which is usually permanent in nature. When it is for the right leg, the whole body should be 1/3 of it.
Yes, my lord. I will try to convince regarding the other heads, my lord. My lord, future medical expenses, my lord. Future medical because, my lord, even I searched in the these Google.
No. When the doctor is very clear, don't search web like that. Then
the legal.
What will happen is Mr. Shastri. 3, this diet and other things 25,000 is granted. No amenities we will not enhance it because we are not reducing in the incidental expenses.
It is left to the court, madam. I am not insisting, arguing on quantum.
Incidental and amenities. Yes.
Future medical.
Where is the future medical? Loss of 1 minute. Loss of income during laid up period.
3 months is awarded.
46,500. Loss of future earning capacity. What is this?
Well, that
also,
is future.
That you are not disputing. 65,100. And
future correct.
Earning capacity or not?
Future earning capacity.
Future medical expenses, my lord.
That we will see.
Yes.
Future medical expenses, court has not granted. What is the evidence of the doctor about
40,000 is the doctor evidence, my lord.
15,000 maybe allowed. 15 to 20.
No, this is an accent of 2020 to 30,000 will award. Yes. So now the enhancement is at 25,000 towards pain and suffering. Future medical expenses 30, that is 30 plus 25, 55 plus 10 legal expenses, 65,000. So 4,95,900. Correct?
Yes,
only one request is, my lord, in appropriate case, my lord, this in appropriate case, my lord, I want to bring it to your lordship notice that once this telescope is formalized, adopted, again, my lord, this deduction is not permissible. I will try to bring to your lordship regarding the materials.
Appropriate cases where the evidence of the doctor is in consonance with your submissions.
They don't know they may not know the legal consequences. That is why even some doctor says the limb disability is.
To tell your counterpart to elicit evidence on that. That would be the right case. Please come. Agreed with the award passed in MBC number 212 of 2022 dated 4th March 2025. Whereby the tribunal has granted compensation of 4,30,900. The claimant is before this court seeking enhancement of the compensation. The tribunal has granted the compensation as per the table given below at paragraph number 21. When counsel appearing for the claimant submits that when he has sustained the fracture injuries, court had granted only 25,000 at the head of pain and suffering. It is submitted that towards the loss of amenities, only 10,000 is granted. Further, no amount is granted on the head of loss of under the head of future medical expenses, and the amount of compensation needs to be enhanced. Next parallel, and counsel appearing for the respondent insurance company submits that on all counts, court has granted a just and reasonable compensation, and there are no grounds to interfere. This court has perused the having heard so and so, perused the entire material on record. Under the head of medical expenses, nourishment, loss of income during the later period, loss of future earning capacity, and also loss of amenities, court has granted a reasonable amount, and this court do not find any reasons to interfere. Coming to the pain and suffering, this court is granting an amount of rupees 50,000 towards the future medical expenses. Considering that there is another surgery to be performed, this court is granting 30,000. In the light of the law laid down in Mekala also so and so 10,000 legal expenses. Altogether, the claimants are entitled for an amount of rupees 4,95,900. Accordingly, the appeal of the claimant is partly allowed. Yes, next.
Cell number 34. Uday Kumar RL for appellant.
Then under 164 of the ME Act after amendment, I pray for short time. It's very simple. I had a cataract, therefore I need a time.
This is matter in the month of January. At the request of learned counsel for the appellant. Yes. Any passwords?
Serial number 17, my lord, in fourth list. Serial number 17 in the fourth list. Sorry, I was held up in portal number 6. I was on my legs on this thing.
17.
Please,
Yes.
my lord. Because this matter is posted from Friday to this day, Saturday to this day. On that day,
That day also you are not present.
no, I was in portal number. I told Mr. Your Rajendra to represent.
That day, like,
yes.
I said that.
Yes, let me come.
No, not you. I said that they will be entitled to withdraw. For that, he said he will stay on the condition of depositing the amount, and on such deposit, they'll be entitled to withdraw.
The complaint after 31 days from the date of accident. 31 days. You are disputed
Ex parte
ex
order.
parte judgment.
But you didn't appear. What to do?
Well, let them appear and let them make an application. My lord,
No, you come to the court with delay of 514 days, and we stop them
my
from
lord, it's
having
an
the
ex parte
amount.
judgment. Ex parte judgment.
It happens.
Kindly see. My lord, ex parte judgment. Kindly see. My lord.
What is the amount granted?
My lord, the amount, my lord, 10,48,000. Huge amount is awarded. It is a false case.
It's a case of death.
Injury. False case. After 31 days, no, we'll wait till the 31 days, my lord. If really vehicle.
No. With all this delay, why should we? They should have the benefit of it.
My lord, it's an
That's
ex
what I
parte
said.
judgment. Kindly see the address of the insurance company, Chola Insurance Company. Kindly see, my lord, in the cost title.
Mm.
They have made some office in the Shivamogga, and we.
Why this? They live in Shimoga.
They have filed execution number, my lord, execution 30 of 2014. Then only we can.
Some amount to be withdrawn, or we cannot, which is subject to the result of the appeal.
That is, my lord, if really, my lord, in the last occasion, I said no objection. But here, my lord, 31 days delay, your Rashmi kindly appreciate, there is some difference between each case.
It is true, but the thing is, notice
My lord,
is
if there is
served.
no delay in
No,
filing the complaint, my lord, I would have fairly
No,
agreed.
the main point is notice is served on you. He didn't appear before the court.
Well, the address kindly see, my lord, they have given the false address. I don't know how it is served or not. It's a false address, sure.
Cholamandala General Insurance Company. What is your address in that place? Now, what is that you have furnished here? Shimoga,
Yes.
same address.
But that office is not there and they have not received.
Branch office, second floor,
On
Malnad
inquiry.
Arcade, Shankar Mutt Circle, BH Road, Shimoga, same office.
But they have not received this thing, my lord.
That how should we, why should we believe
My
that?
lord, I am ready to deposit 100%, my lord.
100%, let is some
But,
amount to be
no,
withdrawn, 25%.
Then, my lord, 50%, my lord, out of 50%, there may be some amount I leave it to your lordship.
The present appeal is filed with the insurance company with a delay of 514 days. It is submitted that it's an ex parte order. No notice is served on the appellant. Further, the complaint is given after 24 days.
31 days.
31 days from the date of accident. Considering the submission of the land council to the appellant, they shall be stay of all further proceedings on the condition that 50% of the amount shall be deposited within 4 weeks. And on such deposit, the respondents are at
1 or 2
liberty.
lakhs may be permitted.
On such
1 or
deposit,
2
the
lakhs.
respondents are at liberty to withdraw half of the amount, half of the 50% deposited amount. Yes,
Much of this.
notice to the respondent. Yes, next. Huh? In which list? No, now we have taken up the, let her call the passwords.
Passwords matters, list number 2, serial number 3,
List number 2?
serial number 3.
Yes.
Petitioner,
Hmm.
I am challenging the auction notice, my lord. The auction is held and third parties purchase the property. I may be given liberty to approach the DRT.
No, that's what I was saying. Why you are enjoying the interim order from the last 1 year?
Yes.
Now, why should, I will grant liberty to approach the DRT subject to the law of limitation.
Section 14, it will not come in, 14 of Limitation Act, my lord.
It has to come in your way. Because why did you come before this court? What is this order of status quo? Now we'll take it to a logical conclusion. Now we will pass an order. When the court has entertained your writ petition and granted you an interim order,
Yes.
now we will pass orders on the merits of it and say, because this is not the way. I'm completely against this principle of granting interim orders, enjoying the interim orders for 1 year, after that relegating the parties to the DRT. Why should we? If that's the case, why the interim order is granted?
With that observation, your lordship made this,
Huh?
this was the liberty to file.
Liberty to
Approach.
file subject
Approach.
to the law of
Yes,
limitation.
Lord,
Yes.
I would like to point out 2 aspects. Here, aside the Milord sale notice dated 30th 12/2024 before this honorable court. The sale not taken place. Subsequent to that, Milord, I issued one more sale notice, which I indicated in my statement of objection. In that sale took place. Sale confirmation taken place.
But that's not the question before this court.
Sale certificate took place.
Then what is the liberty for the?
That's what. Milord, in
No,
fact, we
liberty
not
to
get
the challenge.
No,
other-
we don't, the court need not give you liberty because that is
Please.
not pursuant to a sale notice. The present writ petition is filed questioning a sale notice dated
30th 12/2024.
30/12 or 10.
30/12.
2024.
30/12/2024. And an order of status quo is granted.
Granted on 15/4/2024. That time sale certificate has been issued.
15/4/2024.
2024 IO interim order granted.
2024. Thereafter, the said notice, sale notice is withdrawn.
No, my lord.
Not happened.
That 30th 12/2024, my lord, for want of bidders, the sale got paid. That is assailed before this honorable court. Subsequent to that, I issued one second sale notice on 4/2/2024.
What will happen to the notice on, you have to withdraw it?
It has become, my lord, infectious.
Yes, that subsequently, another sale notice is issued on
14/2/2024.
14/2/2024.
That sale took place on 29/2/2024. Sale took place on 29/2/2024. Sale certificate issued on 28/3/2024. And that certificate got registered in favor of the auction purchase. Thereafter, they approached this honorable court.
That is registered, it is submitted, registered. Now, land counsel appearing for the petitioner submits that he may permit it to, in the liberty may be given to the petitioner to approach the DRT. When the sale notification that is issued on 13/12/2024 is a subject matter of this writ petition, and subsequent notifications were issued, basing on the subsequent notifications already sale certificate is registered in favor of the auction purchaser. In those circumstances, question of granting liberty in respect of this sale notice does not arise. Hence, the writ petition is dismissed.
Sale number 4. Keshawara Agnihotri.
Respondent in this case, first respondent in this case.
Who, you are for the first
They
respondent.
have for weeks time to file objections, my lord.
A week's time is, the land counsel respondent seeks a week's time for filing objections. List this matter on 19th of November.
Much of.
Yes, next.
Sale number 6.
6.
My lord, in 4.1 interim order needs to be extended, please, my lord.
4 into.
In 4.1 interim order needs to be extended, please, my lord.
Interim order earlier granted is extended. Yes, next.
Sale number 6. Rudra Bhushan CB. KV
Pass
Lokesh,
over, again pass over, yes.
cell number 10.
In this case, I'm for the respondent, my lord.
Here for the
Yes.
petitioner, your lordship. Lordship, please see page number 42 and 43, your lordship, bank statement. I have paid substantial amount.
That is what
Even
the
after-
matter is adjourned. I want you to calculate and tell me. Again, I need not look at all those statements and calculate. That's how it is adjourned, is it not in the morning?
Yes, your lordship.
Have you done the calculation?
I have just marked the amount, your lordship.
Why the court will do it?
No, your lordship. Lordship, my humble submission is kindly see page number 43.
I will
your
not see
lordship.
anything. Please tell the court. What is the amount? What is the date?
Date.
Why can't you do that? Pass over.
My lord, kindly have it on tomorrow, my lord. I'm seeking instruction from bank, my lord.
Tomorrow.
Obliged, Your Honor.
At the request of counsel, the respond. Please tomorrow also don't start all this.
Yes, your
Please come
lordship.
up with specific amounts, dates and all. Yes.
Obliged.
Serial number 21.
This number?
Serial number 21.
Which list, ma'am?
Gopal Krishna and
Here is the apparentment, claimant's appeal, my lord.
where is Mr. Somshekara again?
I'm
Manjula,
I'm
you are here.
representing, yes,
Hmm.
Your Lordship.
Yes.
Claim petition filed under 163 is dismissed on the ground, my lord, that other vehicle involved in the accident is not clearly stated. The claim, your appellant is a pillion rider traveling in the motorcycle, and the claim petition filed against the owner and insurer of the motorcycle.
Let's see that. Let's see the finding.
It is a comprehensive policy.
Claim petition has been filed against the insured and insurer of the lorry, Your Lordship.
Not
Okay,
lorry,
facts.
Not
This
lorry,
is-
he says it's against the bike.
bike.
Why is he not entitled? On 163A.
Your Lordship, I think may I read it, Your Lordship? From their case contentions, Your Lordship, it was the lorry which has dashed against them from
Correct.
behind.
Now under 163A,
Yes, Your Lordship.
involvement of the vehicle is what is required.
Yes, Your Lordship.
He's traveling on a motor vehicle. He's a pillion rider. Accident had taken place.
Yes, Your Lordship. My humble submissions are that I was under the impression that because if my lordship is kind enough to take up the matter at 2:30, I will go through the TCR.
Yes, it's 2:30.
TCR and make my submissions.
2:30.
Yes,
Yes,
Your Lordship.
next.
Serial number 25. Serial number 25.
Yes,
KV Nayak.
take that. He has also seen.
Yes, ma'am. Case of injury.
Where is the table?
Table. Page number 20 of the judgment.
The present appeal is filed. Agreed with the word passed in MVC number 2062/2022, dated 17 January 2025, by the claimant seeking enhancement of the compensation. The claim petition is filed seeking compensation of an amount of rupees
20 lakhs, my lord.
20 lakhs for the injuries sustained by the claimant. The tribunal has awarded the compensation as per the table given below.
13 lakhs,
Page
40,000.
number, paragraph number 23. When counsel appearing for the claimant submits that the court had failed to grant reasonable compensation at the head of loss of income during the later period. When it comes to loss of future income also, on what ground is especially?
Income has been increased, 20%, 20%, my lord. As for the date of accident, 15,000 has to be considered instead of 11,500.
The court ought to have taken 15,000 as income, but the court had considered the income at
11,500.
Then the disability is 20%.
20%. 20%.
Future
9
pro-
multiplier.
Then future prospects are considered.
No, my lord. 58 years. 58 years. Because in this, my lord,
He doesn't want.
not a treated doctor, my lord, the 20% is already an higher side disability considered.
Loss of future, and when the disability is 20%, court had granted only 20% towards loss of amenities. Then coming to the 26 days of hospitalization, court had granted only 20,000.
20,000.
Future medical expenses, the court had not granted the reasonable amount. It is submitted that on all the counts, there has to be enhancement. Expert. Land counsel appearing for the respondent company, the insurance company submits that the court had granted a reasonable compensation, no enhancement is called for. This court has having heard so and so, per the material on record. As per, under the head of pain and suffering medical expenses, court has granted a reasonable compensation. It requires no interference. Coming to the loss of income during the later period, considering the fact that this accident had taken place in the year 2021, considering the income at 15,000 for 4 months.
Yes, ma'am.
60,000 this court is granting. Coming to the loss of future income, 15,000 into 12, what is the multiplier?
Bottom I have written.
9.
15,000 into 12 into 20, 12 into 9 into 20 divided by 100 is 3,24,000. Coming to the loss of amenities, considering the 20% disability, this court is granting 40,000. And under the incidental expenses, 26 days of hospitalization, this court is granting 26,000. Future medical expenses, this court is granting 30,000. Where is that 10,000 is not added?
No, sorry.
In the light of the law laid down in Mekla also so and so, 10,000. The 10,000 legal expenses. Altogether, the claimant is entitled for an amount of rupees 14,99,008. Accordingly, the appeal is partly allowed. Enhanced amount shall carry 6% interest.
Cell number 28. Mr. Prasad Keti.
For the appellant. My appeal is for enhancement and.
Your is on the ground of?
Quantum only.
Quantum only. So let's go to that. Where is the
Para
table?
60, page 16.
It's a case of injury.
Injuries.
You have any calculation on this? No, we will do it. What are the injuries?
My lord,
Page 16.
my question is that, my lord, the 32% whole body disability considered by the tribunal is on higher side. That has to be reduced.
That we will go.
In that
First,
regard,
pain-
in that regard, I will.
Pain and suffering, how much?
Pain and suffering, my
has
lord,
to be
3 fractures, my lord.
3 fractures.
3 fractures.
Then another 10,000?
Please, ma'am.
60,000.
50,000 is awarded.
Another 10,000. Then medical expenses as it is.
As it is. Incidental expenses.
1 minute. 6,85,003. How many days was in hospital?
19 days.
my lord.
That will grant 19,000. Then conveyance another 7 plus
Separate,
15 is
it's
more than
separately
that.
granted.
Then we
Anyhow,
will,
my lord, my lordship is recalculating.
so
The
19,000.
2 aids will come
Yes,
to
19,000. Then loss of income during
During the
later
later
period.
Later period has to be increased.
What is the income?
15,500.
15th correctly assessed.
15,000?
500.
For how many months it is
2
taken?
months awarded, my lord.
So we'll take 4 months.
Yes.
62,000.
62,000.
And amenities.
Then what is the disability?
Disability is
32%.
Now we will come to the disability.
Yes, please, madam.
Loss of future earning. Please come to let's go to the
That
paragraph.
disability is concerned, my lord, we have calculated the same disability will come. That's what I want to submit. 32% as that is rightly.
Rightly assessed by
So
the
we will take as it is, 10,71,000.
same amount.
360.
So disability was assessed as 30?
32%.
32% to the whole body.
Whole body. My lordship would have said that rightly considered.
For
by
that future prospects has to be.
Then amenities we have already, amenities now, amenities.
10,000 awarded.
That has to be considerably increased. I have produced the photos. He even now is in
Loss of amenities, how much?
Another 40,000.
How much is granted?
10,000.
10,000.
10,000.
At least 1 lakh rupees maybe. Your lordship may kindly exhibit P7 photos.
Yes, 1 lakh.
And future medical expenses.
What is the future medical?
Second time he was admitted to the hospital because of non-union of the fractured bone. There is loss of bone also.
What is the evidence of the doctor?
1 lakh, the doctor said 50,000 awarded.
So we'll grant another 20.
Another,
Because in that we have already granted substantial, for the amenities, 1 lakh is
doctor says
granted.
few more surgeries he has to undergo. That is why 1,60,000 he has stated.
He has stated
1 lakh. 1 lakh. They
So
stated
we'll-
1 lakh.
We'll
The
grant
MSCT is granted.
another 20,000.
They have stated approximately, that's what 50,000 awarded.
So we'll grant 70,000, legal expenses 10,000.
And few, my submission is 32% to whole body disability.
Future
Youth
prospects are not considered.
Not considered.
Then they are entitled, Mr. Pradeep.
Future prospects, my lordship may hold
Will
that
grant.
judgment.
So income is 15,000?
500.
500. What is age?
20 years.
500.
40%.
Into 40 divided by 100 is 6,200.
12 into 18.
It will be 5 plus 17, 27,000. 700 into 12 into
18.
27,700 into 12 into 8.
14 lakhs 99,904.
You said disability is 33.
32%.
32.
14 lakhs 99,904.
100 is 19 lakh 14,600.
14 lakhs 99,000.
No. No, the income is 20.
If my lordship has added 40%, afterwards 32% would be 9,944. 9,944 into 12 into 18.
No.
Yes, my lord, 32%, that amount will come.
15,500.
Yes, my lord. Yes.
Then for that, 40% future prospects would come to 6,200. His income becomes 27,700.
Correct.
Not 27,000.
21.
21,000.
21.
Instead of 21,700.
Yes, my lord. And 21,700
Into
32%.
100 into 12 into
18.
18
into
into 32 divided by 100.
100.
Is 14 lakh.
Yes, my lord.
14 lakhs.
99,904.
904. We'll make the calculation on that. This one.
Marriage prospects.
1 lakh.
Yes, we will see 1 minute. It's coming to 25 lakhs. Then what about the marriage prospects?
It has to be considered.
Yes, Pradeep?
25 lakhs 6,251.
6,251 is coming. What about the marriage prospects?
Another one.
Lordship has amenities has granted 1 lakh, including that, my lord, it will come.
Another 1 lakh may be added for marriage prospects.
Future prospects also, my lordship is considering. Overall, my lordship awarding
entitled,
25 lakhs
He deserves-
6,251.
We'll say marriage prospects will give 30,000.
That's what my lord, I suggest my lordship amenities 50,000. My lordship has increased to 1 lakh.
1 lakh.
1 lakh. That's what my lord. Otherwise, my lord, I would have said that 50,000 loss of marriage prospects.
That could be 50,000 maybe. And legal expenses.
Legal
Legal
expenses
expenses
already
added.
Calculated. That
25 lakhs
only is coming.
6,251.
50,000 rupees may be future prospect.
That is
marriage
correct. Just compensation.
Yes, please come. Agreed with award passed in MSC number 1931 of 2022, dated 3rd October 2023. Both the claimant as well as the insurance company are before this court questioning the quantum of compensation that is awarded by the tribunal. MFA number for 5503 of 2024 is filed by the claimant, and MFA number 2514 of 2024 is filed by the insurance company. Land counsel appearing the tribunal has awarded the compensation as per the table given below, para 15. The tribunal has considered the disability at
32%.
32%
To the whole body.
to the whole body and granted the compensation. Land counsel appearing for the claimant submits that the tribunal has failed to grant reasonable compensation at the head of pain and suffering. And also loss of income during the later period is considered only for a period of 2
2
months.
months.
It is submitted that coming to the loss of future earning, when the disability is 32%, court ought to have granted 40% future prospects which were not considered. Further, future medical expenses also, the amount that is awarded by the tribunal is not just and reasonable. He is entitled for compensation for the loss of marriage prospects. On all the counts, the compensation needs to be enhanced. When counsel appearing for the insurance company submits that the court without any basis had considered the a whole body disability at 32,000.
32%. 32%.
32%. And when he was in hospital for 19 days, 7,600 is granted towards food and extra nourishment. And also 15,000 is granted for the conveyance that is on the higher side. It is submitted that on all other counts, the compensation that is awarded by the tribunal is just and reasonable. Next, for having heard so and so, so and so. The main contention of the insurance company, it's 36%.
36%.
No, 32. Consider 32%.
No, the actual disability is 36%. Court has taken 32%, but I considered for 32.
The doctor has opined that there is disability for the right limb at 27%,
And arm
for
39.
right upper limb, right lower limb 27%, right upper limb at 30%, and whole body at 36%. This court has perused evidence of the doctor and the injuries that are sustained by the claimant. The court had taken 32% as disability, and this court do not find any reasons to interfere. Considering the injuries that are sustained by the claimant, this court on the head of pain and suffering is granting 60,000. Medical expenses as awarded by the tribunal. Incidental expenses, considering 19 days of hospitalization, this court is granting 19,000. Coming to the loss of future income, considering the disability at 32%, 15,500 plus 40% future prospects would come to 6,200. Then the income is, then it comes to 21,700 into 12 into 18 into 32 by 100 is 14 lakhs
99,904.
99,904. 904. Then loss of hence is entitled for an amount of so and so under the head of loss of future earning. Coming to the amenities, considering the disability and the age, this court is granting 1 lakh. Future medical expenses, the court tribunal had granted 70,000, and the fact that he requires another surgery.
Tribunal granted 50,000.
50, that's what I said. This court is granting 70,000. In the light of the law laid down in Mekhala also so and so 10,000. Altogether, the claimant is entitled for an amount of rupees 25,06,251. The announced amount shall carry 6% interest. Accordingly, the appeal filed by the insurance company is dismissed, and the appeal filed by the claimant is partly allowed by enhancing the compensation from 19,20,307 to 25,06,251.
Amount in deposit in.
Amount in deposit shall be forthwith transferred. Yes. So there are no matters in this list. Passos. In this list. What about the list, Pradeep?
Please, ma'am. Given.
How many matters?
51 and around 20. Around 72.
Have you informed the others also? Other
Just I given list, madam.
It's yours only.
Company, Sriram General Insurance Company 51 million. CFC's mine is 21 million.
What I'm saying is, inform to the other colleagues
I will
also,
inform.
let all of them come. So everybody will have that list. Tell her that
Millard, in
there are
that
still
Millard, in 21 I given, that is failed in the local adalat Millard, that has to get it to.
No, we will pass orders.
Please.
Serial number.
It will be called.
Yes. Sir.
5780 ಇದೆ.
Sir, serial number 6, list number 2.
ಮೇಡಮ್ ಕಂಟಿನ್ಯೂ ಮಾಡ್ತೀರಾ? ಪಾಸ್ ಓವರ್ ಆಗಿದೆ.
ಪಾಸ್ ಓವರ್ಸ್ ಇದೆ ಸರ್, ಪಾಸ್ ಓವರ್ ಇದ್ರೆ ಇದೆ.
ಮಧ್ಯಾಹ್ನ
ಯಾವ್ದು ನಿಮ್ಗೆ ಯಾವ್ದು ಸರ್?
ಲಿಸ್ಟ್ 2 ಅಲ್ಲಿ 4.
ಹಾ?
ಲಿಸ್ಟ್ 2 4.
ಲಿಸ್ಟ್ 4 ಅರ್ಜೆಂಟ್ ಆಯ್ತಲ್ಲ 11 ಗೆ. ಲಿಸ್ಟ್ 2
ಮೇಡಮ್ ಪಾಸ್ ಓವರ್ 2 ಕರೀತಾರಾ?
1911 ಗೆ ಅರ್ಜೆಂಟ್ ಆಯ್ತು ಅದು. It is called out Keshavar Agnihotri sir. It is once again passed over. It is called out at that time of calling the case you are not present. That respondent counsel ಇಟ್ರು, ಅದಕ್ಕೆ ಅವರು 1911 ಗೆ ಅರ್ಜೆಂಟ್ ಆಗಿದೆ. That list number 2 pass over matters I called out.
ಮೇಡಮ್ ಲಿಸ್ಟ್ ನಂಬರ್ 2 ಸೀರಿಯಲ್ ನಂಬರ್ 6 2 ಕರೀತಾರೆ.
It is 1911 sir.
ಇಲ್ಲ ಮತ್ತೆ ಪಾಸ್ ಓವರ್ ಆಗಿದೆ. ಮೇಡಮ್ ಸೀರಿಯಲ್ ನಂಬರ್ 6 ಲಿಸ್ಟ್ ನಂಬರ್ 2
Again it is passed over.
2 ಕರೀತಾರೆ ಮೇಡಮ್. ಓಕೆ ಥ್ಯಾಂಕ್ಸ್.
EI ಸನ್ಮತಿ. ಸರ್ ಮಧ್ಯದಲ್ಲಿ ಲಿಸ್ಟ್ ಕ್ಲೋಸ್ ಆಯ್ತು. ಲಿಸ್ಟ್ ಕ್ಲೋಸ್ ಆದ್ಮೇಲೆ ವಿ ಹ್ಯಾವ್ ಟು ಕಾಲ್ ದ ಪಾಸ್ ಓವರ್ಸ್. ಯಾವ 4 5 is 4 ಆದ್ಮೇಲೆ ಕರ್ದಿರೋದು ನಾವು. 5 2:30 ಅಂತ ಮೆನ್ಷನ್ ಆಗಿದೆ ಅದು. ಎಸ್ ಸರ್. 2511
ಆರ್ಡರ್ ಆಯ್ತು.
ಏನ್ ಆರ್ಡರ್ ಆಯ್ತು? ಅದೇ ಆಗಿದೆ.
ಅಲೌಡಾ?
ಹಾ ಐ ಅಲೌಡ್.
ಆಯ್ತು. ಸೀರಿಯಲ್ ನಂಬರ್ 8 ಅದು ಐ ಅಲೌಡಾ? ಸೀರಿಯಲ್ ನಂಬರ್ 8
ಅದು ಆಯ್ತು ಐ ಅಲೌಡ್.
ಯಾವುದು ಅದು ಡೇಟ್?
ಅದು 2511.
2511 ಓಕೆ. ಆಮೇಲೆ 13 ಸೀರಿಯಲ್ ನಂಬರ್ 13.
ಸರ್ ನೀವು ನಮ್ಗೆ ಊಟ ಮಾಡಕ್ ಹೋಗ್ಬಿಡಲ್ಲ.
ಗೊತ್ತಾಗಲ್ಲ ಮೇಡಮ್, ನಾನು ಇಲ್ಲೇ ಇರ್ತಿದ್ದೆ.
ನೀವು ಸುಮ್ಮನೆ ನಮ್ಗೆ ತುಂಬಾ ಎಂಬ್ರಾಸ್ ಮಾಡ್ತೀರಪ್ಪ. ಅದು 311 ಹೋಗಿದೆ ನೋಡಿ.
311
ವಿಘ್ನೇಶ್ ಶೆಟ್ಟಿ. ಯಾವ್ದು ಹೇಳಿ ಸೀರಿಯಲ್ ನಂಬರ್?
ಲಿಸ್ಟ್ ನಂಬರ್ 4 ಸೀರಿಯಲ್ ನಂಬರ್ 13 ಫಸ್ಟ್ ಟೈಮ್ ಬಂದಿರೋದು.
13 ಅಲ್ಲಿ ಇಫ್ಕೋ ಟೋಕಿಯೋ EI ಸನ್ಮತಿ ಅಂಡರ್ಟೇಕ್ ನೋಟಿಸ್ ಟು R2 ಆಗಿದೆ. ನೀವು ಡಿಸ್ಪೆನ್ಸೇಷನ್ ಮೆಮೋಸ್ ಮೋಸ್ಟ್ ಆಫ್ ದಿ ಮೆಮೋಸ್ ನ ಫೈಲ್ ಮಾಡಿ ಸರ್. ಅಲ್ಲಿ ಇಲ್ಲಿ ಏನಾಗುತ್ತೆ ಗೊತ್ತಾ, ನೀವು ಎಲ್ಲೋ ಗಡಿ ಕೊಟ್ಬಿಟ್ಟು ಇಲ್ಲಿ ಏನಾದ್ರು ಮಿಸ್ ಆಗೋಯ್ತು ಎಲ್ಲ ಎಡವಟ್ ಆಗುತ್ತೆ. ನಾನು
ಮೇಡಮ್ ಇಲ್ಲೇ ಇದ್ದೀನಿ
ಸರ್ ಡಿಸ್ಪೆನ್ಸೇಷನ್ ಗೆ ಹ್ಯಾಂಡ್ ರಿಟನ್ ಮೆಮೊ ಕೊಟ್ಟರೆ ಓಕೆ ಆಗುತ್ತಾ? ಸರ್ ಡಿಸ್ಪೆನ್ಸೇಷನ್
ಏನಂತ? ಹೌದು.
ಈಗ ಅಲ್ಲಿ ಬೆಳಗ್ಗೆ ಹೋಗಿ ಅಲ್ಲೇ ಮಾಡ್ಬೇಕಷ್ಟೇ. ಇಲ್ಲೇ ಕೊಟ್ಬಿಡೋರು.
ಇನ್ನೊಂದು ಮ್ಯಾಟ್ರ್ ಇತ್ತು ಹೋಗ್ಬಿಟ್ಟಿರ್ಬೋದು. ಗೊತ್ತು. ಅದೆಲ್ಲ
ಯಾವಾಗ ಬರುತ್ತೋ ಬರ್ಲಿ, ನಾನು ರೆಡಿ.
Court officer? Court officer? Court officer? Court officer? Court officer?
ಸರ್ ಹೇಳಿ.
ಇದು ಲಿಸ್ಟ್ ನಂಬರ್ 4 ಸೀರಿಯಲ್ ನಂಬರ್ 14 and 15 ಫಸ್ಟ್ ಟೈಮ್ ಬಂದಿದ್ದು ಏನಾಯ್ತು ಅಂತ ಹೇಳ್ತೀರಾ? 14 ಮತ್ತು 15
ಅದರಲ್ಲೆಲ್ಲ ನೋಟಿಸ್ ಆಗಿದೆ ಸರ್.
ನೋಟಿಸ್ ಇನ್ಶೂರೆನ್ಸ್ ಕಂಪನಿ ನೋಟಿಸ್ ಆಗಿದ್ಯಾ?
ಹೌದು, ಇನ್ಶೂರೆನ್ಸ್ ಕಂಪನಿಗೆ ಟೇಕ್ ನೋಟಿಸ್ ಆಗಿದೆ, ಇನ್ನು ಉಳಿದಿರೋ ರೆಸ್ಪಾಂಡೆಂಟ್ ಗೆ ನೋಟಿಸ್.
ಹೌದಾ, ಯಾರು ಅಂತ ನೋಟ್ ಮಾಡ್ಕೊಂಡಿದ್ದೀರಾ ಮೇಡಮ್? 14 ಮತ್ತು 15
14ರಲ್ಲಿ ಡಿ ವಿಜಯಕುಮಾರ್ ಸರ್.
ಕೇಳ್ತಾ ಇಲ್ಲ. ಹಲೋ,
14ರಲ್ಲಿ ಡಿ ವಿಜಯಕುಮಾರ್ ಸರ್ಗೆ ಟೇಕ್ ನೋಟಿಸ್ ಆಗಿದೆ R2ಗೆ.
ಆಯ್ತಮ್ಮ, ಆಯ್ತು. ಥ್ಯಾಂಕ್ ಯು. 15ರಲ್ಲಿ
ಪಿ ಪ್ರದೀಪ್ ಸರ್.
BP. ಥ್ಯಾಂಕ್ ಯು ಅಮ್ಮ, ಥ್ಯಾಂಕ್ ಯು ಸೋ ಮಚ್. ಥ್ಯಾಂಕ್ ಯು ಸೋ ಮಚ್.
ಮೇಡಮ್ ಬಂದ ತಕ್ಷಣ ಯಾವುದು? ಮೇಡಮ್ ಬಂದ ತಕ್ಷಣ ಪಾಸ್ ಓವರಾ? ಮೊದಲು ಪಾಸ್ ಓವರಾ?
ಸರೆಂಡರ್ ಮಾಡಿಸಿ ಯಾವ ಕೆಲಸ ಕೊಡ್ತಾರೆ ಏನ್
ಹೋಗುತ್ತೆ ಅಪ್ಪ ಕೇಳಿ ಅಂತ ಹೇಳು.
ಅದೇನೋ ನಿಮ್ದು ಇದೆಯಲ್ಲ
ಕಾಲ ಇತ್ತು ಬಂದಿಲ್ಲ.
ಪಬ್ಲಿಷ್ ಮಾಡಿ
Passos. Then we'll take up the 230 list. Passos first.
Passover matter, list number 2, serial number 6.
And for the petitioner in this case,
Yes.
that's I had already argued in this case, my lords. That's I had pointed out that,
Yes.
my lords, page number 19 may be looked into of my.
What is the order impugned?
My lords, section 14 order was challenged before DRT. And section 14 order was passed on 15/6/2023. My lord, section 14 order is an administrative order. Section 14 order will be passed without the presence of the borrowers, that is respondents. And we get to know when the respondent bank issues vacation notice.
About the limitation you are.
Yes.
Yes, what do you say on this?
Lord's section 14 order, settled principle of law that none of the section 14 order borrowers, this
Correct.
court, various courts have held.
There is no dispute on
In
that.
this case, he had challenged position notice because 13(2) is first issued, granting 60 days time to the borrower. After 13(2), 13(4) issue, basically not under the Surface Act. 13(4) is a cause of action to file an appeal before DRT or to challenge the proceedings before appropriate court of law. In this case, in the present petitioner had filed an appeal challenging section 14 order before DRT, which was dismissed and which was upheld in favor of the bank.
Why?
In favor of the bank, he challenged position notice, and after position notice, section 14 order is passed. It is not disputed that he has not challenged position notice.
Sir, copy.
So,
Yes, sir.
30th August 2024, you are aware of this?
My lords, I don't have the copy of the order. I don't have.
So once 13(4) questioning the position notice, when your application itself is dismissed, what are the grounds now?
In the petition, it states that it is pending for adjudication, but it is dismissed on merits. And very same borrower, very same bank. There are multiple accounts where more than 30 crores.
Lords, can I?
But this court will not relegated into DRAT in previous case. There he is a petitioner, bank is a respondent. Maybe loans are different. But in fact, at the time of dismissal of the case, my learned friend considered before this court that he will go before DRAT. Similar such order may be passed because this under section 18. The 17 has to be challenged, and this court has already held, division bench of this court has already held, that limitation by DRT cannot be condoned. It's a certain.
No, it cannot be condoned. That's why it's a pure question of law. It is like this. Now, what is that section 40? What is 17?
Section 14 order, yes.
No. Limitation is under which provision?
17(1).
17(1). It says from the date of order passed under section 14, 45 days. So, if admittedly, he will not be, that would not be in the notice of the borrower because his presence is not required for passing an order under 14. After an order under 14 is passed, unless and until you issue a notice to him or you go and take possession or whatever you do consequential to that order, he will not be knowing it.
As per Act, section 17 mandates only after issuance of 13(4). Before 14, 13(4) is issued.
Let's read.
13.
Act. So
Section 14 is not a cause of action to.
that's what we'll see. 17. We'll read 17.
17.
One minute. Yes.
Lord, section 17. Any borrower, any person, including borrower, aggrieved by an act of the measure referred to in subsection 4 of section 13, taken by the secured creditor or his authorized officer under this chapter, may make an application along with such fees as may be prescribed to the debt recovery tribunal having jurisdiction.
So it is referring to 13(4) notice.
13(4), not section 14. 14 is not a cause of action. And here,
can I make some?
And already has made it. That is already dismissed.
It is dismissed, and court has told that what all proceedings initiated under Surface Act is.
Okay, that is done. That is done. Now he is questioning the order under 14. He cannot question the order under 14 before DRT.
Question the order under 14.
I can, ma'am.
The thing is, until 13(4), all the section 14 is the administrative order, where the magistrate has to see whether demand notice has been served on the borrower or not, whether position notice has been served on the borrower or not. That's
So for going before the DRT and for any of the limitation under section 17, it has to be calculated from the date of 13(4),
Yes.
but not on any other subsequent proceedings.
It can be challenged, it can be challenged.
Can be challenged, but the limitation would be from the date of such 13.
Yes, yes, yes. No, the limitation from the date of order of section 14 also limitation will arise for him. But he can't come and say, I'm not having knowledge of section 14.
But he would
Because
not have.
13.4 was challenged by him. And after 13.4, what does bank will do? Bank will go for section 14 for taking physical possession of the property.
I'll tell you, today morning I have seen one case. You have made an application under section 14 a year ago. Even till now, the magistrate has not passed the order. So we cannot say that immediately after 13.4, unlike within no time 14 is passed.
It's a tactic what borrower uses, because 13.4, the only stringent condition, stringent action which the bank takes against the borrower is taking physical possession of the property. They'll wait 13.4, they don't challenge. In this case, it has challenged 13.4. They'll wait until section 14 order is passed to file an appeal before the act.
So 13.4, what did the court say?
Court says, my lords, that court has upheld, even assuming for a fact, my lords, what for the sake of argument, even section 14 is challenged before DRT. What section 14, what pleadings he can raise in section 14 is that the demand notice is not issued, 13.4 is not issued, 13.4 only is upheld. This court,
No, let's see. No. Let us see from this, from the writ petition. What is that he has raised under section 14? Let us see that impugned order.
Can this court turn page number 22?
22 of your writ petition.
22
Hmm.
of my writ petition.
Hmm.
There is a reason given by the tribunal.
No, not about the reasoning. I'm asking on what grounds you have questioned section 14, that we will see.
Page 27.
27.
From 27 it starts. Your Lordship will find relevant paras facts of the case in page 29.
Yes.
Facts of the case, Lords. Para 5 facts of the case.
Mm.
So may kindly come to para. This is grievance will start from C. It is submitted to the appellants are given reply to demand notice and denied the contents of demand notice. The appellants are that is demand notice it was yes replied. Kindly come to page 30 minutes. Para D. It is submitted to the respondent bank without considering the reply given by the appellants, without complying section 13(3) of the Surface Act, as issued the alleged position notice dated 16/2/2023. Appellant filed appeal against the position notice on dated 16/2/20 before this honorable tribunal essay 162.
So your only ground for questioning the 3014 notice is that an order under section where you have questioned 13(4) in an essay, order is not passed. It is pending consideration. So issuance of 14 order by the magistrate is bad is the only question that's raised by you.
That is only one, Malaj. And the second one.
The second we should find from here.
Yes, the second one is, Malaj, this is not filed by me, Malaj, but I will point out.
However it is, let's see.
Yes, Malaj, page number 31, ground number 6.
Please read.
The appellant filed appeal against the possession notice dated 16/2/2023 before this honorable tribunal in essay 116 of 2023. The above appeal is still pending and posted for objection and hearing. During the pendency of the appeal, without filing objection statement in the appeal, during the pendency of the appeal, the respondent bank suppressed all the facts and filed section 14 petition. That is 1. And 2, the respondent has not reduced the amounts already paid by the appellants to their loan amounts while issuing the surface notices. So and so obtained ex parte order is not according to the law, and respondent has not filed any proper affidavit before the chief judicial magistrate. That is, according to section 14 provision, they have to file a affidavit along with the petition stating that whether any appeal or any application is pending before any court of law. Malaj, at the time of section 14 petition, which they had filed, the 13(4), the matter was sub judice before the DRT. The honorable DRT was still considering my essay.
But it has not passed any interim order.
There was no interim
So
order.
there is no impediment for the court to pass any order.
Yes, Malaj, but the authorized officer of the respondent bank, he had to file an affidavit before the magistrate stating that there is no pending application or appeal before any court of law.
Coming back to the order.
Section 14, no such mandate is
there.
Section 14, no such thing is there.
Malaj, at least there has to be. Malaj,
This is not the way we allow the.
Malaj, can I make one submission? Can I make one submission?
Yes.
Malaj, on 15/6/2023, section 14 order is passed. 2/8/2023, I get a vacation notice. And 15/8/2023, I file an essay. And my lords, page number 22 may be looked into.
I've already looked.
The Honorable Tribunal is stating that if they were not aware of the order dated so and so, it was solely because of their lack of follow-up. My lords, how can the borrower follow up before the
Go into
magistrate?
all that. Let's not go into all that.
That is
The
one.
only point that remains is, the only ground that you have raised under section 14 is that your essay is pending consideration.
Yes.
Pending consideration of the IA, that is filed questioning the proceedings under 13(4).
Yes.
They have issued the section, the section 14 order came to be passed.
Yes.
Now you have lost your appeal itself,
Well,
your
that's-
essay itself. So there are no valid grounds to question that 14 at all.
My lords, can I put it this way? My lords, let this honorable court condone the delay of 5 days and let this court send it back to DRT for fresh consideration of essay on merits.
What is there? What is there? What
Well,
is there for this 14? You have to tell one good reason.
My lords, the affidavit has to be filed according to the provisions of
Let
section
us see, let us see where is that.
Yes, my lords.
Let's read section 14.
Yes, my lords, section 14.
Hmm.
My lords, I'll directly go to the relevant
Hmm.
on the receipt of the affidavit from the authorized officer, the district magistrate or the chief judicial magistrate, as the case may be, shall, after satisfying the contents of the affidavit, pass suitable orders for the purpose of taking possession of the secured assets within a period of 30 days from the date of application. And that is one. That if no order is passed by the chief judicial magistrate or district magistrate within the said period of,
What grounds an order under section 14 can be questioned by the borrower?
my lords,
On what grounds?
my lords, if there is a
Say when the act itself says that section 14 order, no, the participation of the borrower, notice to borrower is not required.
Yes.
That is a consequential action to 13(2)(13)(4).
Yes,
14 is the order.
yes, my lord.
So now whatever that you are pointing out, what is the bearing of it in an order under 14? What is the law on that?
My lords, I will point out that in the next date of hearing by giving some citations, my lords, but I have a right to.
When you're coming to the court, you should come with all the citations
Yes.
which are in your favor.
Every time in this.
Yes,
court,
madam.
inlines this
I-
undertaking of the close the entire loan account. But this
Even
was
that
having
was
lot of
fine.
conditions.
Hmm?
Lot of these
Even that was
lot of
fine.
conditions.
Let him complete. How will I listen? What
Yes.
is-
Previously, this, when the matter was, the matter comes up for any adverse order against the appellant, the petitioner here, he had filed an undertaking affidavit stating that he closed the entire loan account. This court told to file an affidavit and he had filed an affidavit. In affidavit was full of conditions imposed by him as per his means and branches, saying that he'll close the loan account in March 2026. And as per he'll offer a one-time settlement to me, all these things. So my, let him 1 week time may be granted. Let it be related to DRT. He'll appeal. Agreed by the, let him go before DRT. And same order, what has been.
No, why you do not want the court to decide the legal issue?
That already this question of limitation before this court. has
That we can
settled.
decide. There is a question of sending it to DRA. That's what I'm asking you. What I'm asking you is, this writ petition is pending from 2024. Interim order is granted. The court has entertained. He enjoyed an interim order. And is it not against your client also? Unless he enjoys the interim order, again goes back and starts another proceedings.
For approaching DRAT, the question is why he has not gone to DRAT is that a 50% precondition is mandatory before DRAT.
No, that is one aspect. Second is when it's a purely a legal question, why can't we decide it? That's what I'm asking you.
Because it become a precedent and now DRAT.
Why precedent? It is, what is wrong with it? It's good for you. It is not, it will not become a, now if that you have to, if you have to take precedent every day in and out, I'm seeing the writ petitions. Already so many precedents are set up.
Court has already held in various cases. In fact, any order under DRAT under section 17 has to be filed.
Then what were you doing for
bench
the, why this interim order is granted in this case?
Plus 25%
A
was.
writ petition,
25%.
I'm telling you, a writ petition which is not maintainable, in that in an interim order is granted and he is enjoying it from 2024.
Interim orders are granted only for a temporary relief for the borrower and with an bonus for the bank also by imposing some conditions. It is the final order. There is no one such final order where my learned friend should show that where this court has allowed such case.
No, in all the matters,
Was only temporary
in all these matters, I'm going to take a view that once a writ petition is entertained and once an interim order is granted and a party is enjoying the order for a considerable time, at this point of time, relegating the parties, it's a pure abuse of process, either ways.
Interim order was only.
And wasting the court's time, second point.
In this case, in fact, very little.
No, I'm not, I think there is some apprehension to you. What is that apprehension? I'm not able to understand. That what is, no, on a legal issue, it's a legal issue. Yes, it's a legal issue. On a legal issue, this court can entertain a writ petition in spite of a fact that there is an alternative remedy. It's a pure legal issue whether this writ petition, essay is maintainable before the court, but in view of section 17. That's a question of law. That we will decide if you argue on that.
In this case, Lords, it can't be decided only for the fact that the appeal filed by before DRT is dismissed.
That may be one of the grounds to decide dismiss it. At the same time, this court can pass an authoritative pronouncement on that aspect. Two issues. That abuse has already been done. So let us not further aggravate it.
Court has been only for it because section 14 order, they come before this court at the back end of the day and say that bank might take physical possession of the property. So to just save them for it, it is the duty of the petitioners to come before bank again, offer some settlement, repay some.
Will it ever happen?
Yeah, nothing happened.
Not about this case. Is it happening ever?
Malaj, can I make?
In any of the cases? Mr. Counsel, I am inclined to entertain this petition on the question of law, and I will pass an order. You please assess the court on that issue of limitation, whether it is maintainable or not, whether the court was right or not. And this will come within the parameters that is laid down by the Honorable Apex Court in several judgments as it goes to the question of law. When we are entertaining so many writ petitions on facts, why not a writ petition on a question of law?
My only question is if interim order is not extended, my account might get settled in 10 days. Interim order is not extended. The only thing is here, interim order is the only crux here.
You should also be fair to the court and to the other side. When you want an order to be vacated, why can't you argue on the merits?
I'm ready for argument.
On the limitation aspect. Yes. Now let's go to the order impugned. Now, will you please tell the court, section 17 speaks about 13(4) notice and limitation from there. Yes. Now, if somebody wants to question a 14 notice, where the limitation starts?
Limitation starts from the date of the order.
Date of?
From the date of the order. From the date the magistrate passes the order. From that date.
And admittedly, it is an order where it's an order where the presence of the borrower is not required.
Yes, that is.
So, how will he know? That's a simple question. How will he know? He will only know once you have pasted that notice on their asking them to vacate the property basing on 34. After 34, what are you supposed to do?
13(4).
Not 13(4), after 14.
After section 14, directly physical possessions are taken.
Question is taken. Before that, what you do? You will affix it to give him a day, or like you mention the time, date, order. That's how they will come to know.
There is no such practice, but on
no, but what the law says, what the act says.
There is no such.
Let's see what the act says. Come to 14.
Directly come to section 14(1)(a).
No, let's read from 14.
But where the possession of any secured asset is required to be taken by a secured creditor, or if any secured asset is required to be sold or transferred by secured creditor under the provisions of the Act, the secured creditor may, for the purpose of taking possession or control of any such secured asset, request in writing to Chief Metropolitan Magistrate or the District Magistrate, within whose jurisdiction any such secured asset or documents relating thereto may be situated or found, to take possession thereof. The Chief Metropolitan Magistrate, or as the case may be, the District Magistrate shall, on such request being made to him, take possession of such asset and documents relating thereto, and forward such asset and documents to the secured creditor, provided that any application by the secured creditor shall be accompanied by affidavit duly affirmed by the authorized officer of the secured creditor declaring that. That's what my letter at that time was submitting some governments has to be incorporated. The aggregate amount of financial assistance granted.
Provided further that on receipt of the affidavit from the authorized officer, the district magistrate or the chief metropolitan magistrate, as the case may be, shall, after satisfying the contents of the affidavit, pass suitable orders for the purpose of taking possession of the secured debts within a period of 30 days from the date of application.
The just where it's continued, that is provided that any application by the secured shall be accompanied by an affidavit. What are the contents of the affidavit is enumerated from I till that is aggregate amount, what is the amount sanctioned, the borrower has, what is the secured asset which is created, the borrower has created security interest over various properties, and the bank or the financial is holding a valid and subsisting security interest over such properties, and the claim of the bank or financial institution within the limitation period. The 3 million, the borrower has created security interest over various properties, giving the details of the properties referred into clause I above. The borrower has committed default in repayment of the financial assistance granted, aggregating the specified amount.
There are no rules.
There are no rules. No, for section 14, rules does not prescribe any conditions forthwith. Only for 13.2 and 13.4 rules states that how demand notice has to be issued, how 13.4 has to be issued. Section 14, the act in the act itself, it's absolute. What are the duties of the magistrate to be followed? What are the duties of the authorized officer to be followed? Now, I file my affidavit. Magistrate will go through my affidavit. What primarily magistrate should see is that demand notice and position notice, whether they were served in accordance with of the.
We are not going to that aspect of whether you have complied with all 14 conditions or not. We are only on the point when section 17 of the act deals with the limitation of 45 days from the date of 13.2 order, 13.4 order. If he is questioning that particular notice under 13.4, act is silent about questioning an order of 14. So now we are implying it that it should also be from the date of order 45 days. Is it not?
Yes.
So this, as far as 13.4 is concerned, it's a notice that you have directly issued to the borrower. So it can be considered from that date. But when it comes to 14, admittedly for passing a 14 order, his participation in the proceedings is not required. That is between you and the magistrate. In that case, definitely that date cannot be reckoned as a date of limitation for filing any application for any appeal before the SA before the DRT. So what should be the other date? It necessarily be the notice that you affix on his premises. From that day, the limitation has to be looked into.
So under the Act, Section 14 is not a cause of action. Subsequently, Supreme Court in the Honorable Apex Court in Kanayala Sachade held that Section 14 order is also a cause of action for any borrower to challenge before DRT. It's a questionable order before DRT. So no, it should be entertained. And on that aspect, it was there before Apex Court. Apex Court has held it. But my lords, there's no such loan, no bank will issue any such. Law does not prescribe under Section 14 also. After Section 14 order, notice should be given to him for evicting him.
Yes. So that is given when?
That is not there.
That is not there. There is a precedent on it.
Notice.
There is a precedent on it.
No, you don't even affix 14 notice.
Act does not prescribe that. There's no such provision to be followed under this.
But anyway, you have done it in this case.
In this case, vacating notice was given to.
That's what. So he understood whatever that has happened under 14. Once you have given that notice to vacate the premises, so his cause of action should necessarily start from that day. That 45 days period will start from that day.
Act will, even though Section 14 would not be a cause of action, but under Section 13.4 it is 45 days. So within 45 days you should have filed the appeal. That's what.
No, this order of the DRT is not about 13.4. The DRT said the Section 14 order was passed on so and so. You should have been, should have been keeping track with what is happening next proceedings. So he considered the day under Section 14.
It's the cause of action. What this in fact.
That's what I said. I am going to pass an order. So if you want, please pass. Or even if you are ready to place some other judgments also, I'll give you time.
Latest one, Lord. This is not. There's no stay or any.
Let's see which page. Paragraph.
This last paragraph. 4.7, page 14.
Yes.
Law of limitation may harshly affect 4.7. This is a very, in this case, DRT had dismissed the appeal on merits, on limitation. This was challenged before DRAT. DRAT also dismissed on limitation. So this was challenged before this honorable court. This honorable court held as follows. Law of limitation may harshly affect a particular party, but it has to be applied with all rigor when the statute so prescribes. Court have no powers to extend prescribed period of limitation on the grounds of equity and justice. The view gained support from P.K. Ramachandran, State of Kerala, Thomas M. Cooley, an acclaimed American jurist. So I'll skip and I'll just come to page 15.
Absolutely, there is no dispute on this proposition. Either ways it affects, party has to. Now, because what is not dealt with by the act has to be interpreted by the court now.
So that's what such situation arises before this court, where it's the very same argument what my learned friend is, what the petitioner is making. Very same, where he told that I was well within limitation to the date of the knowledge. From the date of knowledge, I had filed my appeal. That was very same contention were taken. And just such circumstances, already this court has held that the law of limitation DRT does not have powers to condone the delay under the act.
No, it has no power to. Now, this court also is not saying that it has a power to condone the delay. We have, now the cause of action arose to him on a particular day. It has to be 45 days within as per section 17. That's what I'm going to say. When the act do not say that there is a power to condone the delay and it is shall, it has to be. Court cannot go beyond that and say that there can be. But now, when the limitation starts is a question in this case.
But
can I make one submission?
He's telling that from the date of knowledge, it should be from the date of order. He's only contending before DRT. Was that
If the date of order, the date of order would come, provided he's a party to the proceedings. He is not a party to the proceedings. How can we say, is it not unreasonable to say that though you are not a party, still you should know and your limitation starts from that date?
He'll be monitoring, he should be aware of what happens. Like from 13.4, from 13.4 is a cause of action, and what else?
I'll reserve this matter. You want any orders to be, any judgments you're relying on?
One date.
Yes, that's what I said from the beginning. I'm saying that. This is
one last submission, Malad. This order here.
I am not, when I'm not considering that order, why you want to submit on that?
Yes. Sale notice is
challenged. This is matter on 4th of November. At the request of Learned Counsel for the respondent, this the interim order granted is extended till then.
Great.
Yes.
List number 4.
20. Paper appellant in this case, ma'am. Not which in this case, paper appellant. Oh, shit. Not audible, my lord. Court is not audible. Why? What is not audible?
Inspector, in the report.
Yes.
Appear, in this case, appear for the appellant, my lord. Sorry that there was disturbance in the claim petition filed under 163 dismissed on the ground that
Have you heard her argument?
no, my lord, there was no actually. There was some disturbance in.
If your lordship permits.
We'll have it some other day. This is matter on 13th of November.
Obliged.
Yes,
Obliged.
next.
Cell number 30.
Appear for respondent number 2.
Yes.
Claimant's appeal for enhancement, my lord. Case of injury, my lord.
Lisa. Come to the table.
Table is page number 25, my lord.
How many are the injuries?
Injuries, two grievous injuries, my lord. Page number 19, injuries are explained, my lord.
Yes, Mr. Bethur, 50,000 for pain and suffering. Medical expenses, any dispute?
No, my lord.
How many days was in hospital?
He is from 27/5/2022,
7 days.
8 days, my lord.
Huh?
8 days.
Already enough amount is granted, will not interfere. Incidental expenses.
Future earning capacity, my lord.
Then, what is this loss of future earning?
70 years, my lord.
70 years.
My lord, he has suffered 24%, my lord. Tribunal has taken 7%. It has to be taken 8%, my lord. Whole body. Kindly peruse the payment.
So what is the income?
14,500.
14,500, my lord.
14,000?
500.
What is the multiplier?
5.
5, my lord.
Disabilities?
Particular limb doctor assessed 24%, tribunal taken 21%, then 1/3 deducted 7% whole body. It is correct.
8% is to be taken, my lord.
If it is taken 8%, how much it will come? It comes to 69,600. We'll take. Then loss of income. How many months it is granted?
3 months, my lord. He is a aged person, my lord.
That is taken correct, my lord.
We will grant 1 more month.
Yes, my lord.
Loss of amenities, another 5,000.
Yes, my lord.
20,000. It's coming to 4,16,100. Please come. Agreed with award passed in MVC number 711 of 2021 dated 22nd January 2024. The claimant is before this court seeking enhancement of the compensation. The tribunal had granted the compensation as per the table given below at paragraph number 18. Then counsel appearing for the petitioner submits that when the petitioner has sustained 2 grievous injuries under the head of pain and suffering, the court had not granted a reasonable compensation. Further, under the head of loss of future income, when the disability is 8%, court has taken 7% and has not granted a reasonable amount. Coming to the loss of income during the later period, only 3 months is considered. Further, for the disability of 8%, the court under the head of loss of amenities has granted only 15,000. It is submitted that on all counts, the compensation needs to be enhanced. Next paragraph. When counsel appearing to the respondent insurance company submits that the court has considered all these aspects and has granted a reasonable compensation and no enhancement is called for. Next paragraph. Having heard the counsels on either side produce the material on record. Considering the injuries sustained by the claimant, 2 grievous injuries, this court is granting 50,000 and the head of pain and suffering. As far as the medical expenses and incidental expenses are concerned, this court is not interfering. When it comes to the loss of income during the later period, considering the age and the injuries, this court is considering for 4 months. That is 14,500 into 4 is 58,000. Coming to the loss of amenities, loss of future earning, this court is taking the disability at 8%, 14 to the whole body. 14,800 into 12 into 5 into 8 per 100 is 69,600. Loss of amenities considering the disability of 8%, this court is granting 20%, 20,000. In the light of the law laid down in so and so, is entitled for legal expenses in the light of the law laid down in Mekala also so and so, is entitled for the legal expenses of 10,000. Altogether, the claimant is entitled for an amount of rupees 4,16,100. Accordingly, the appeal of the claimant is partly allowed, enhancing the compensation from 3,62,900 to 4,16,100.
Entire amount can be
Is partly allowed. The amount in the entire amount shall be the appellant is entitled to withdraw the entire amount. Yes, next.
No problem.
An enhanced amount shall carry 6% interest. Is condoned on condition
Yes, sir.
or without condition.
115 days.
Yes.
115 days.
Next.
Interest is,
It is 6%.
madam.
That is not condoned on condition.
No.
Already it is just like that condoned. Earlier.
Earlier it is condoned.
Yes.
without condition.
Next.
No. List number 5. For orders matter, serial number 1.
Needful done, my lord.
Then council submits that the needful is done.
I make one mention,
This matter after service of notice. Yes.
Serial number 2.
one matter is passed over, my lord, that is not called.
But this RPFC, it is not
Please,
called.
sir,
It's
I have informed my learned friend for referring the matter, he is agreeable, my lords, for that.
We are agreeable.
Yes.
Please.
In
List 3, serial number 8, my lords.
List number 3, serial number 8.
Eight.
Both the parties submit that the matter may be referred to the local.
Mangalore Mediation Center.
Bangalore Mediation Center. The party shall appear before the court on 8th of October.
Mangalore mediation.
Mangalore, my lords.
Mangalore mediation on 11th of November.
Please.
They should appear on 11th of
List 3,
November.
serial number 8.
List 3, serial
Yes,
number
it is passed over in the morning.
Please.
Yes, next, call the list.
Serial number, list number 3. Serial number 1 finished. Serial number 2. Serial number 2. Awaiting.
Yes, Mr. Shastri. Awaiting TCR. Where is Mr. Lingaraj HS? Not to be seen. They're appearing. Where is Mr. Sripadri Shastri? Claim petition is dismissed in this.
Yes, my lord.
Is
TCI
dismissed.
members.
List this matter after TCR is received.
Serial
Yes,
number
next.
3. Serial number 3. All to Reliance General.
Have they given the list? Have they given the list at least now? Where is the list now? Here it is not there. Why she will take in the chamber? It was there in the morning.
Mom, he asked me.
Which is the company?
Reliance General.
R2 or R1?
R2, ma'am.
R2 is for Reliance General Insurance. The who appears for Reliance General Insurance? Mr. D. Vijaykumar is directed to take notice on behalf of the respondent insurance company. Notice to for the issuance of notice to R1, the process shall be paid within a week, or else the appeal shall stand dismissed against R1. Next 4.
Then number 4, Panchamardi.
My lord, I am for the response. Ready, my lord.
For the appellant in this case, my lords.
What about R1?
My lords, notice to respondent number 1 which I will discuss.
Yes. Memo is filed seeking dispensation of notice to R1. Memo is taken on for record and notice to R1 is dispensed with. You ready?
Please, my lords.
Yes. Give the file.
There's a delay of 363 days.
I number 1024 is filed to condone the delay of 363 days, condoned on condition that they will not be entitled for interest for the delayed period. Yes, what is this case?
My lords, case of injury, my lords.
Where is the table? Come to the table.
My lords, page number 32, my lords.
Yes.
The injuries,
What are the injuries?
My lords, fracture shaft of humerus right middle, 1/3 grievous injury, my lords, and other simple injuries, my lords.
Only one grievous injury.
Please, my lords.
So 40,000 is reasonably granted.
18% was the disability, my lords, assessed by the doctor.
No, one is pain and suffering.
Please, my
Then how many days he was in hospital?
My lords, 9 days, my lords.
Huh?
9 days, my lords.
Incidental expenses, 9,000. Yes.
My lords, no amount was awarded for.
One minute.
Please, my lords.
Court has granted 10,000 already. So
Yes.
we'll take it as 10,000. Then hospitalization and medicines, only 3,500.
Please, my lords.
What is the disability according to the doctor?
My lords, 18% to the upper limb, my lords. My lords, page number 23, my lords.
How much the court
Para
has taken?
16, my lord. Para 16 of the judgment.
Read it.
Please, my lords.
Yes.
In this backdrop, the functional disability is to be assessed by the tribunal. The doctor PW2 deposed that the petitioner is suffering from disability at 18%. PW2 in his cross-examination, he has deposed that the fractures were united. Further, PW2 deposed that the petitioner finding difficulty in doing movements in right shoulder and weakness in right wrist and fingers. The disability assessed by the doctor is only for right upper limb. Further, PW1 in his cross-examination has deposed that he being an employee in Radiant Taylor Company has been continued his job till 2020 and he has
It should have been something, the court just like that. It could have, because he's working, that doesn't mean that he'll have the disability.
No loss of income at all. There is no loss of income at all. He is getting more income than what you are getting. Therefore, where is the question of loss of, unless the injury and disability is resulted in a loss of future income, then only is entitled. Here, my lord, some amount,
Loss
extra
of
amount may be
amenities-
awarded towards, my lord.
Loss of amenities will grant
Amenities, yes.
another 50,000.
Please, ma'am. Please, ma'am.
25 plus 75,000 altogether. Yes,
In the other aspect, my lord, I don't think.
nothing else. Future medical expenses, what is the evidence of the doctor?
No doctor, nor certificate so far. Still, it is awarded with interest.
So 30,000. Then loss of income during later period.
Lords, it's 25,500 lords has been awarded.
That is loss of
Loss of
income
earning
during the
during laid up period, my lords.
First column, first column.
Which year is the accident?
2014.
2014, my lords.
Then what was he doing till 16?
2020. But
Lords, petition was filed in the year
2016.
2016.
Because it's a simple injury, my lord.
It's a grievous injury, my lords.
2014 is 8,500. Court has granted. It is renewable, will not increase anything. 500.
Only under
legal.
the head of loss of amenities.
My lords, had he not met with the accident, my lords, he would have had better prospects, my lords.
It's coming to 1,94,000. Court had granted 1,24,000. Please come. Agreed with award passed in MAC number 1262/2016, dated 2nd June 2023. The claimant is before this court seeking enhancement of the compensation. The tribunal has granted the compensation as per the table given below at page 23. Extract the table. When counsel appearing for the appellant claimant submits that the court had failed to grant a reasonable compensation, it is submitted that towards loss of amenities, the court had granted has granted only an amount of rupees 25,000, and when it comes to the loss of future income, court has failed to grant any compensation by applying the multiplier. It is submitted that the amount on all counts needs to be enhanced. Next, when counsel appearing for the respondent insurance company submits that court has rightly not granted compensation as the accident has happened in the year 2014, and even in the year 2020 the respondent is working. That's why the court has not granted any compensation, though the doctor has reported that he has sustained 8% to the limb.
18%.
18% limb.
Whole body disability.
4%.
4%.
1/4. For upper limb, 1/4. Lower limb, 1/3.
Though he has suffered 4% disability, it is submitted that the court had rightly granted the compensation. No interference is called for. Next paragraph. Having heard the counsel's findings, the said person material on record. Under the head of pain and suffering, the court had granted a reasonable amount. No interference is called for, even under incidental expenses and the expenses relating to hospitalization, medicines. Court has granted a reasonable compensation. Coming to the future medical expenses, this court is granting 30,000. Loss of income during the later period, court had rightly considered and granted. Coming to the loss of future income, in the considered opinion of this court, the court has rightly not granted any loss of future income. But however, as far as loss of amenities is concerned, this court is granting 75,000. Next, in the light of the law laid down in Mekala versus so legal expenses 10,000. Altogether, the claimant is entitled for an amount of 1,94,000. Accordingly, the appeal of the claimant is partly allowed, enhancing the compensation from 1,24,000 to 1,94,000. The enhanced amount carries 6% interest.
Number 5.
Regarding future medical expenses, no interest. That has been awarded, not awarded by the tribunal.
Was it absorbed by the tribunal? Huh?
Yes.
Where is that?
Page 24 and 20.
As for
Operating portion of the judgment.
The amount on future medical expenses will not carry interest. Yes, next.
Much of this.
This condoned. This court has condoned the delay of 363 days on condition. As such, the appellant is not entitled for the interest for 363 days. Yes.
Cell number 5. Sandhya D.
For the appellant minutes. Notice to respondent number 1 may kindly be dispensed.
Memo is fetching a dispensation of
Matter may be
notice
referred
to
to
R1
other.
dispensed with. Ready?
Matter may be referred to.
What
other.
is this? What is this?
Injury
Case of
minor.
injury marks for
We'll see.
And now
He's there. Yes, let's see. Come to the.
the accident is of the year 2016, my lords. The injury
This
sustained.
entire thing is in Kannada.
The synopsis marks will help, no? No, I will not dispute marks with regard. Synopsis marks is carrying all the details.
How many are the injuries?
Cut lacerated wound on over the medial lacerated right foot, my lords.
How many grievous
One leg,
injuries?
one.
There is both bone fracture.
Both
marks of
bone
the right
bone
leg.
fracture.
Doctor has assessed marks to the limb at 19%.
No. Let's see. Pain and suffering will grant 50,000.
Please.
Then medical expenses as it is. 51,555. How many days was in hospital?
5 days, my lord.
So that's already incidental expenses as it is. It's 5,000. Court has already granted 10,000, so will not interfere with that. Then loss of earning during later period. Which year is this?
2016.
16 is 9,500. Court has granted?
9,500.
Oh, it is 4 months is granted, so that also no enhancement. Then, according to the doctor, what is the disability?
It is 19% to the limb
Ah,
and 7% is taken by the tribunal to the whole body at 7%.
so reasonably taken.
7% is taken.
Ah,
But it is rightly taken.
that's what I'm saying.
Yes.
So where they need enhancement?
My lords, the injury he has suffered, he was working as a,
No. As per the evidence of the doctor, 19%, 1/3 has to be taken. And whatever is the income, you're not disputing the income. List this matter as part of tomorrow. Amenities also for 8%, 30,000 is granted. Future medical expenses, 40,000. What else you want? List this matter as part of tomorrow. Look at it and come.
Cell number 6, D. Vijay Kumar.
But I am for the appellant, my lord.
Mallikarjun.
For having paid costs of rupees 1,000 to the lawyer. What happened to this? Reject, Mr. Vijay Kumar.
This is the case of my lord, negligence.
1,000
of
costs.
That I'll get the information.
Huh?
I'll get the information. If not deposited, it will be deposited.
Why your company will directly come and deposit or you will deposit? Order sheet.
I will deposit. Within 2 days, I will do.
This order is passed when on 16/9/2025. This is matter next week. As the petitioner, the appellant has failed to pay the costs as ordered by this court. Next, IA number 1024 is filed to condone the delay of 99 days condone. In MFA 7057, MFA crop, IA number 1025 is filed to condone delay of 26 days. Both the delay is condoned for the reasons stated in the accompanying affidavit. Yes.
Can be disposed of, my lord.
Huh?
It's a case of death, my lord.
Pay the costs.
I'll pay it to the authority, my lord. We have to pay it to the library. That will do it.
You do it and come back day after tomorrow.
Please.
Day after tomorrow.
Yes. Cell number 7. Cell number 7.
This case appear for the respondent wants notice is dispensed to the
Ah. A memo is when seeking dispensation of notice to R.
R1.
R1. Memo is taken and notice is dispensed with. Where is Krishna Swami?
A.N. Krishna Swami.
Where is he? No representation on his behalf.
Today is not in station.
Huh?
Today is not in station.
Where is his junior?
Only announcement I will assist.
Huh?
It's only
What is the case?
Only announcement of.
Let's see.
Oh. Case of injury, fracture of the femur and also several fracture of the
IA number 1024 is filed to condone the delay of 158 days, condoned on condition.
left knee and left leg. Doctor assessed the disability 56%, my lord.
To the limb.
Limb.
How much is taken?
Only 18% is taken the tribunal might.
18 into 3 is what?
Correct, but 56% is
It's
fracture.
54.
And also income is only 13,000 is taken the income.
We will take 19. Pradeep, we'll take 19%. Court had taken 18%. We will take 19%. And which year is the accident?
21.
21 it should be?
15,000.
15,000.
15,000. Court had taken?
13,000.
13,000.
So please come to the table.
28 para.
How many are the injuries?
Fracture estimate.
Fracture is only one fracture, madam.
So we will grant another 10,000
Mm.
pain and suffering. Medical expenses as it is, that 3,15,377.
28 days.
28 days was in hospital. But court has already granted 45,000
Double.
incidental expenses. Then loss of income during later period. That is, you said 14,000,
15,000.
15,000.
2021.
Mm.
Yes, ma'am.
So 15,000 into 4,
60,000. 60,000.
60,000.
Arvats
Then loss of future earning.
Mm.
So 15,000 into 12, what is the multiplier?
13.
13. 46 years.
Huh?
46
13
years.
multiplier 46.
13 into 19 by 100.
4,44,600.
4 lakh?
44,600.
Yes. Amenities, loss of amenities.
25,000.
That's already
Another
granted.
10,000.
Please. Litigation has already
And
granted.
cost of litigation.
Already granted.
First time I'm seeing trial court granting cost of litigation. Which court is this?
Bangalore. Court.
Mandya.
Mandya.
Oh, February 2024 order.
Malvalli.
So it becomes how much?
Yes. 40,000. Yes. 15. Yes. 47. Yes.
It's coming to
9,49,977.
977. Yes, please come. Agreed with the award passed in embassy number 804 of 2021, dated 3rd February 2024. The claimant is before this court seeking enhancement of the compensation. The tribunal has granted the compensation as per the table given below at paragraph number 28, extract. Then counsel appearing for the claimant submits the court had failed to grant a reasonable compensation as considering the injury sustained by the claimant. It is submitted that the court had considered, as this accident has happened in the year 2021, court had taken the income at
Income is 15,000. 15,000.
15,000.
Telkotal only income is awarded 13,000.
That's what in MSCT considered 13,000.
20,000.
court had taken 13,000 as income. It is submitted that when the doctor had stated that the claimant had sustained disability of
56%.
50?
6.
56%.
56.
56% to the whole body. Court had taken how much?
18%.
18%.
Court had taken 18%. It is submitted that needful is done. List this matter after service of notice.
Cell number 10. Cell number 10.
Who is R1?
Appear for appellant, my lord.
Cell
Needful
number
done.
13. Other two respondents.
Today is needful done, my lord.
Non-compliance of office objection raised on PF, that is for R2.
Appearing for
It is
R2.
submitted,
The one
PCC
more
Talam.
matter is connected.
Appearing for R2 insurance company.
papers are served on you?
No.
No, the papers on them. No, it is submitted that the needful is done.
Yeah,
The one more MFA is connected, my
1
lord.
minute needful is done. Then counsel for the appellant shall serve the copy of the appeal memo on the counsel for the respondent. List along with, give the slip.
Okay.
Give right on the slip and-
Already this honorable court already tagged the matter, my lord. One MFA, one
You
for
give
nine.
that number, list along with so and so. Case 11,
Cell number 11. KV Nayak.
who is R2?
R2 is the owner of the vehicle, my lord. Order
Diabetes
for
on
pay and
who?
recovery order, my lord.
Oh, the list after service of notice.
Cell number 12.
Memo is filed seeking dispensation of notice to R2, dispensed with
13.
R2 and R3.
Yes, ma'am.
Where is
R1 is sold.
no representation for the appellant? Admit post for final hearing, call for the TCR.
Cell number 13.
No, in 1 minute, in 12.1, also memo is filed seeking dispensation of notice to R3 and R4. So same memo is taken on record and dispensed with at the risk of appellant. Yes, next 13.
Cell
For the
number
appellant,
13.
my lordships. My lordships, we have already served copy to R2, my lordships.
Huh?
We have served copy to R2, my lordships.
Who is R2?
United India.
To whom you have served?
Shri Shaila, sir.
Mr. Sri Shaila is directed to take notice on behalf of the respondent insurance company. Then counsel submits that they have already served the notice on the counsel. I number 1025 to condone the delay of 10 days, condone, admit post for final hearing, call for the TCR. 14.
14.
Paper appellant counsel, my needful done is.
It is submitted that the needful is done. Who are the respondent insurance company? Oh, it is by the insurance company. It is submitted that the needful is done. This is matter after service of notice. 15.
15.
I paper appellant, my lord. And already copy served, my lord, 10/8/2025 through WhatsApp
Yes.
message, my lord.
Who appears? Sri
Sri
Shaila.
Shaila, Sri Shaila, my lord.
Then what about notice to R1?
R1 may be, notice may be dispensed.
Memo
with,
is
my lord.
filed seeking dispensation of notice to R1. Then counsel for the appellant submits that already notice. Appeal papers are served on the counsel for the insurance company. Admit post for final hearing, call for the TCR. Yes,
Cell
next.
number 16.
Delay of 482 days may be condoned without interest, your lordship.
I number 1025 is filed to condone the delay of, no, what about notice to R1?
R1 is necessary party, madam. Dispute.
After service of notice,
Records is required, madam. Dispute.
admit, no, once let him come, the registry is directed to call for the TCR.
Please, madam.
17.
Cell number 17. KV Nayak.
List this matter after service of notice to R1.
Cell number 18.
17 connected matters there, my lord. TCR is required. in this.
A call for the TCR in 17. Yes, 18.
53 days delay will be conducted. 53 days.
The notice is awaited in respect of R1.
R1.
We can't condone the delay. 18.
18.
List this matter after service of notice on R2.
Hearing on the year 19.
Yes.
I am for the appellant, my lord. So delay
I
may be
number
condoned,
1025 is filed to condone the delay of 303 days condoned on condition that they will not be entitled for interest for the delayed period. Admit post of final hearing, call for the TCR.
20.
Maybe refer to the Lok Adalat, my lord, in this case.
What is that?
Serial number 19 marks is a case of death.
Both of you are ready?
It is only marks with regard to the income, not according to me.
Please
Nothing
give that
marks which is,
19.
Coming there.
My lord, it may be referred to the Lok Adalat, my lord.
Why to refer to the Lok Adalat? We will decide it here. Yes. You will get a better amount here than the Lok Adalat.
9,000 is taken, Manods.
Which is the MVC?
MVC is Manods 18 of 2019.
Where is the table?
Please, Manods. Table, Manods, is Manods, page 23 of the judgment. Internal base 23, Manods. Loss of dependency, Manods, is awarded.
So, what is the age of the deceased?
She was 29 years age. The
Yes.
income is taken at Manods 9,000.
Yes.
for the, the year of the accident is 2018, 12,500 needs to be taken. If that is taken and reassessed, the loss of dependency will be 23 lakhs 80,000.
Now let's calculate.
Please.
Income is 12,500.
12,500 for the year 2000.
Future prospects, how much?
40%.
40% future prospects. It's coming to 5,000. That is 17,500 into
12 into 17.
17 is a multiplier.
17 is in 29 years.
17,500 into 12 into 17. No, but how many are the dependents?
3 are the dependent. One third.
Third has to be deducted. Oh, it's already deducted. So
yes.
17,500 into 1 divided by 3. It comes to 5833. Minus. It comes to 11,666 into 12 into 17.
Yes, ma'am.
19.
It comes to 23 lakhs
80,000.
How many are the claimants? 3 in number.
3 in numbers. Yes, ma'am.
19.
What is the discussion that is happening between all of you? No, that you can write on a paper and see. Don't disturb the court.
There will be announcement of 6,66,000.
1 minute, 1 minute. It comes to 2 lakh 25 lakhs 58,000. 1,32,000 towards consortium.
Yes, ma'am.
36,000 funeral expenses.
Yes.
10,000 legal expenses. It comes to 25 lakh 58,000.
There is medical expenses of
How much?
2,437.74 paisa.
2,000.
437.74.
437.
437. And 4,000 towards conveyance.
No, all that we.
No, it is already granted. If your lordships are recalculating the entire amount, that needs to be taken. If your lordships are taking the entire amount.
Yes. No, all conveyance and all, those are not the heads, that's how we calculate.
No, here by the tribunal it is already granted.
But still, when we are doing the recalculation, all that we will not look into.
Then it will get reduced by that amount. We have to take into account that also. Because the tribunal is granted, we have satisfied the amount.
It comes to 25 lakh 60,000 437. What is granted is 18 lakh 85,000.
Yes,
what is the difficulty now?
I will calculate this.
Total it's a recalculation amount instead of
please.
Heads doesn't matter to you. Ultimately, amount matters.
Yes, that's right.
Yes. Please come. Agreed with award passed on MEC number 18 of 2019, whereby the tribunal has granted compensation of 18,85,037.74. The claimant is before this court seeking enhancement of the compensation. It is submitted that the tribunal has taken the income at 9,000 when the accident had taken place in the year 2018 and ought to have taken 12,500. And on all the counts, the amount, the compensation that is awarded by the tribunal is not a just and reasonable compensation. Land counsel appearing for the respondent submits that the tribunal has granted a reasonable compensation. Next, for having heard so and so, considering the tribunal had granted the compensation as per the table given below at paragraph number 29. The this accident had taken place in the year
18.
18. Considering this court is inclined to consider the income at 12,500 as per the table. 40% future prospects would come to 5,000, that is 17,500. There are how many claimants?
Three claimants.
Three claimants, one third has to be deducted. That comes to 5,833. And his contribution to the family would be 11,666 into 12 into 17 is 23,80,000. Then the loss of consortium, 3 into 44, 1,32,000. Funeral expenses, 36,000. And in the light of the law laid down in Mekala also so and so 10,000 altogether. And the medical expenses of 2,0437. The claimant is entitled for an amount of rupees 25 lakhs, 60,437. Accordingly, the appeal of the claimant is partly allowed by enhancing the compensation from 18,85,037 to 25,60,437. The enhanced amount shall carry 6% interest.
Yes, may I say?
Cell number
That's
20.
4,000 which is already granted. We would have satisfied that. Your lordship need to add that 4,000 rupees towards conveyance. Because she was there for hospitalized for about 5 days. That's why conveyance is granted.
Yes.
That amount needs to be added. Otherwise,
Conveyance, this court is not interfering.
Please, I'm sorry.
That comes to 25 lakhs, 64,437. Yes.
Cell number 20. Satish Shetty for appellant. B.
Yes.
Pradeep.
Ready, madam. It's a case of injury.
Yes,
Nita, madam.
take that.
Case of injury, madam. Lordship, only interference is the loss of income during later period and loss of future earnings. The loss of future earnings, 10% whole body disability as
No,
considered.
1 minute, later period, court had taken how much?
12,500.
Income is taken at?
12,500.
It has to be 15,500.
500.
It has gone at 46, we have to grant 54. Medical expenses as it is. Future medical expenses?
I put an underline, my lord, on that, my lordship, not required interference, right side column. Only later period, 46,500.
Earnings also not to be interfered.
46,500, my lord.
No,
Later period.
15,500 into 12 into 12%.
Future earnings, my lord, from bottom, last line. And there itself. Instead of 1,05,000.
Pain and suffering not to be interfered.
Please.
Loss of amenities not to
Yes.
be interfered. Attendant charges not to be interfered. Laid up is already granted from 46 to 54.
No, my lord, 12,500.
Only 12,500, 1 month.
No, now.
No.
It is
46,500.
then what is this 46,500?
That's later period. Medical expenses, 54,000
I
something.
understand that. You have given two figures. Oh, it is like by.
Please.
Yes, it's 46,500. Medical expenses 54 as it is. Future medical expenses 15,000 as it is.
As it is.
Doctor assessed 30,000, but tribunal consider 15%, 15,000.
63-year-old, my lord, ankle fracture. He
Then
stated that
future earning, what is this? For court has granted how much? 2,62,007.
by considering 10% whole body disability. My lordship,
Comes to 3,57,312.
my lordship has to consider 12% disability. 36% particular limb has been assessed by the doctor, PW3. MSCT considered 10%. I have calculated 12% only. Yes.
Altogether, you have.
But from the bottom total I have mentioned.
3,57,312, including 10,000.
including
Yes.
10,000.
Please come. Agreed with award passed in. MSC number 1859 of 2022 dated 17th November 2023, whereby the tribunal has granted the claimant is before this court seeking enhancement of the compensation. The tribunal has granted the compensation as per the table given below at paragraph number 29. When counsel appearing for the claimant submits that the tribunal had failed to grant a reasonable amount under the head of loss of income during the later period and towards the future loss of earning when the disability as per the doctor is 12% to the limb, court had taken 10%.
36% to the limb.
12% to the whole body, court had taken 10%. It is submitted that on all these counts, then the compensation needs to be enhanced. Then counsel appearing with the respondent submits the court has granted reasonable compensation. There are no grounds to enhance the compensation. Next, coming to the having heard so and so, so and so. The tribunal has granted the compensation as per the table given below at page 29. Correct, 29. As rightly argued by the learned counsel for the insurance company and the head of pain is something loss of amenities, attendant charges, nothing, there is nothing to interfere. Coming to the loss of income during the later period for 3 months at 15,500, this court is granting 46,500. Medical expenses also, no medical and future medical expenses, no enhancement is called for. Coming to the future loss of earning, the tribunal ought to have taken 12% as disability. 15,500 into 12 into 7 into 12 by 100 is 1,56,250. In the light of the law laid down in make allowances so and so 10,000 towards legal expenses. Altogether, the claimant is entitled for an amount of rupees 3,57,312. Accordingly, the appeal of the claimant is partly allowed by enhancing the compensation from 2,62,072 to 3,57,312. The enhanced amount shall carry 6% interest.
Number 21.
Appearing for the petitioner, my lord.
Yes.
So 530 days delay.
Appearing for respondent number 2, my lords.
IA number 1 of 24 is filed to condone the delay of 530 days, condoned on condition that will not be entitled for interest. Have you served the copies on the counsel for the respondent?
Today itself I can serve, my lord.
We have not been
Submitted that
served,
they'll
my
serve the
lord.
copies today. Admit post for final hearing, call for the TCR. Next 22.
Obliged.
In 20, I number 1 of 24 is filed to condone the delay of 195 days, condoned on condition. The same shall be reflected in the order. Yes,
Cell number
20.
22.
Yes.
There is a delay of 116 days, my lords.
Who are the respondents?
There are so many.
Insurance company is there.
Oriental Insurance. R1 and 2 are the owners. my
What
lord.
is R4 is? 1 minute, 1 minute. Mr. Ravish Beni is directed to take notice on behalf of R4. Next R5. New India Assurance. New India Assurance, who appears?
New India Assurance, sir.
You appear. Mr. Ashokan Patil is directed to take notice on behalf of the New India Assurance Company. Then R6. Then what is this insurance company? Gold is it? Shivanagowda is directed to take notice on behalf of R2.
22. No,
R2.
22
Now who are left for the notice? Huh?
Serial number?
22 there. My lords, in 22 there are only 3 respondents.
This is 23, ma'am.
What you have taken, what file? 3034 of 2025. Give the file.
22 is Oriental.
Three 3034 of 25.
Oriental Insurance Company. Mr. Ashok and Patil is directed to take notice on behalf of R3. Notice to
R1 and 2 may kindly.
R1 and 2. Notice to R1 and 2 is dispensed with. Serve the copy on him.
I'll serve.
A delay of 116 days, condoned on condition, admit for final hearing, TCR. Next 23. Who are they?
Sixth respondent.
R2 like the earlier order. R2, Mr. Shivanagowda.
My lord, company also challenging another 2 appeals, my lord. See, R2 Muralidhar.
Wait, what is that? List along with so and so. Give the numbers. List along with so and so next week.
New India,
So like I'll just adjourn this matter. List along with so and so. Yes, 24.
Cell number 24.
I'm for the ready.
Yes, of injuries.
Come to the table. In this 24, I number 1 of 25 is filed to condone the delay of 272 days, condoned on condition. Yes. Where is the table?
Internal page 6, at page 10, ma'am.
Para 20.
Fracture of left femur, proximal multiple abrasion of right temporal region, left knee, eyebrow and forehead.
How many injuries?
8 days.
One fracture and 3 injuries.
Fracture is one.
Only
Fracture.
So we'll grant 50,000.
Yes.
Next,
Loss of income during later period,
which year is the accident?
2022.
How many
15
days he was in hospital?
9 days.
days. 9 days he was in the hospital.
Which year you said?
22. 15,500 correctly assessed.
That is correct.
How much is granted?
But 2,80,000.
15,500.
4
Into-
months.
Huh?
4 months.
For 5 days hospitalization.
9 days.
9 days.
9 days.
15,500 into 3. Into 3. 46,500.
Yes.
Then,
Loss of income.
then my loss of income during, how
Future.
much is transport incidental charges? 20,000.
Yes.
That is nothing to enhance. 20,000. It's already on the higher side. Then loss of income on disability. Income.
That is
The
on higher side only.
BW2 doctor has
Loss of
assessed
income
47.
due to disability. What is according to the doctor? What is the,
47% to the limb and 16% to the whole body.
what did the court take?
Court has taken only 8%.
Why?
47% ಹೇಳಿದೆ.
This is doctor evidence.
Please.
This is the doctor evidence. Total disability of the left lower limb 47%, whole body disability 16%.
So 15,500 into 12 into,
We have not believed the evidence of PW2 doctor.
there should be a basis for not believing.
Yes. Allah, it is clearly stated, my lord, fracture is
15,500
united
into
well.
12. What is the multiplier?
Multiplier, according to me, it has to be 17. This is,
31 years.
as per the date of birth, 30 years, 8 months. He has not completed that.
Half of it is already complete.
Yes.
Half of, but
16
Supreme
multiplied is
Court-
correctly applied.
The age is what?
Yes,
31
is
years.
30 years, 8 months.
He has not become 31.
No, not become
So 30 is how much?
17.
Lord, is almost 8 months more
It
than.
can't be. You can't. 75 paisa is not 1 rupee.
Yes. 17 multiplier.
But it's up to 30. 31 to 35. Now it is 31.
So he is not. He has not come to 30.
There is no proper clarity in that, this thing, my lord.
17 into 16 by 100.
If your lordship were to see the assessment of disability by the doctor, my lord, for single problem, he describes in 6 to 8 types of this thing, and for each 5% he assesses. Kindly see the evidence.
Loss of amenities another 10,000.
Future medical expenses, doctor says 60,000.
Court has granted.
Not granted.
Which year is the accident?
22.
22.
Will grant 30,000.
That's all.
It's coming to 6,72,420. Please come. Agreed with the award passed in MVC number 5648 of 2022, dated 3rd August 2024, whereby the claimant is before this court seeking enhancement of the compensation. The tribunal has granted the compensation as per the table given below at page number 20. When counsel further petition submits that when the doctor has reported that there is a whole body disability of 47, limb disability of 47%, and a whole body disability of 16%, without any basis, the court had taken 8%. And under the head of loss of amenities, loss of income during the data period and future medical expenses, reasonable compensation is not granted. Then counsel appearing for the insurance company submits that the court had rightly granted the compensation and there are no grounds to interfere. It is submitted that the court has not believed the version of the doctor. As such, the court had not taken 16%, but only taken 8%, and there is no illegality with the said order. It is submitted that on all other counts, the compensation that is awarded by the tribunal is just and reasonable, and no interference is called for next. Having heard the counsels on either side, there is a material none on record. The tribunal had granted when it comes to the pain and suffering, considering the one grievous injury and other simple injuries, this court is granting 50,000. Coming to the loss of income during the data period, as just an accident of 2022, this court is taking the income at 15,500 and for 3 months 4,46,500. Incidental expenses court has granted at 20,000. This court do not find any reasons to interfere. When the doctor has reports that there is a whole body disability of 47% and limb disability of 47% and a whole body disability of 16%, on what basis the court has not considered the same is not known. Hence, this court is inclined to consider the income. I consider the who is that also talking continuously. Considering the income, disability at 16%, 15,500 into 12 into 17 into 16 by 100 is 5,05,920. Under the head of loss of amenities, tribunal has granted 20,000 and this court do not and the granting an amount of rupees 30,000. Legal expenses when it comes to future medical expenses, doctor has reposed that he requires 60,000. This court is granting 30,000. In the light of the law laid down in Mekala versus so-and-so legal expenses 10,000. Altogether, the claimant is entitled for an amount of rupees 6,82,420. Accordingly, the appeal of the claimant is partly allowed by enhancing the compensation from 3,13,580 to 6,82,420. The enhanced amount shall carry 6% interest. There, the claimant is not entitled for interest for a period of 272 days.
Cell number
And
25.
also future medical expenses.
On future medical expenses.
Much of
25 DM Srinivas Reddy.
Case of injury, my lord, we filed the for announcement. There is a delay of 16 days, my lord.
No, anyhow, notice has to go. Who are the respondents? R2 Tata AG, who appears? Mr. Pradeep is directed take notice on behalf of the insurance company. What about other?
R1 is, I will file the memo to.
Memo is
delay.
filed seeking dispensation of notice to R1. Dispense
Yeah,
with I number 1025 is filed to condone the delay of 10 days. Condone.
Connected,
Same thing in the next 25.1. I number 1025 is filed to condone the delay of 16 days. Condone. Admit post for final hearing. Call for the decision. Yes. 26.
For the petitioner, sorry, appellant.
Who appears? GS Marulaya.
Marulaya.
No,
He is not
let's this matter. It's coming up for final hearing or admission?
Admission.
It's coming up for interlocutory. Admit post for final hearing. Call for the DCR. 27.
My lord, let it be in the admission stage only.
Let it not be. Yes, 17. 37.
27.
You ready?
Case of injuries.
What are these both MBCs? MBC
MSc 1159 of 23.
Against that,
Against KSRTC.
MFA number is
MFA number is
3339.
3339.
3339. Next
Of
other
20.
MEC is
Next matter is MEC 1178 of 23.
1178 of 23.
MFA number
MFA number?
3476.
Huh?
MFA number 3476.
3476.
Both are injuries.
So first, let's see, MFA 3339.
3339.
Where is the table?
Table is at page, internal page 13.
What are the injuries?
Right forearm segmented shaft fracture of ulna, right radius shaft fracture, 2 fractures. So far pain
Court
and
has
suffering.
already granted 80,000,
Yes,
no
I have
enhancement
I
is
have no
called for.
grievance. Medical expenses as it is. Loss of income on account
1
of.
minute, let me write it. And then loss of income, no, that will not go, let's go. What about future medical expenses?
Future medical expenses, doctor says 60,000.
30,000 is reasonable.
Yes.
Next, what about the incidental expenses? How many days he was in hospital?
For
6 days.
6 days.
6 days.
We'll grant 6,000. Then, loss of income during later period,
For 3 months.
what was granted? Nothing is granted.
Nothing is granted.
Which year is the accident?
2022.
15,500 into 3.
Court has taken
Comes to 46,500. And now come to the loss of future earning. What is the disability?
disability is according to the doctor 40% and whole body 13%.
What did the court take?
48% court has taken.
Why?
No reasons.
Yes, as we'll take as per the evidence of the doctor, 1/3 of it,
Yes,
1/3 of that, my lord.
13%. Court had taken 8%.
8%.
So we'll take 13%. So 15,500 into 12, what is the multiplier?
62 years.
7 into 13 by 100. It comes to 1,69,260. Loss of amenities, what is granted?
20,000 is granted.
For the disability of 13%.
Yes.
We grant another 10,000.
Yes. Laid up period not given.
Huh?
Laid up period not given.
I would have given
Yes. That's all.
plus 40,000 plus 46,500 plus 6,000 plus it's coming to 3,78,227 against 2,37,267. Yes, where is the next table?
Yes.
MFA 347.
My lords, if I make one submission, my lords, we had deposited 4,03,000, so that's why it came to be dismissed. So 4,03,000 was already paid on behalf of the appellant.
What is dismissed?
Your lordship, please look at internal page number. I don't have the judgment.
No. When amount compensation is 2,37,000.
We had paid compensation in interim compensation well in
He
advance.
is right.
So
this also ought to be dismissed, my lord, because it's well within the limit.
why did you file? Why did you file? What about the next one? Next one also
we
same?
have deposited.
Next matter also same thing.
Please come. agreed with orders passed in MBC 1159 of 2023 and MBC 1178 of 2023. MFA 3339 of 24 and 3476 of 23 is filed. When the matters came up for a hearing, land council appearing for the respondent submits that in MVC number 1159 of 2023, an amount of rupees 2,37,267 is granted. And in the other appeal, what is the amount?
91,165, my lords.
91,165 is awarded. The respondent RTC has paid in MVC how much? Level 1159?
In
1159, he paid 2,37,300.
No. He has paid.
4 lakhs, my lords.
4 lakhs,
4
he has
lakhs.
paid. He has already paid 4 lakhs. And in MVC 1178 also, the more than the award amount, they have already paid.
My lord, award amount was in the next petition was about 51,000, but I have paid 91,165.
In MVC 1178, it was 51.
40
They paid
40,000, 40.
Huh?
40,000 was the award amount.
Award amount, you have paid 90,000.
91,165.
91,000. It is submitted that in view of the same. The appeal itself is not maintainable considering the submission. Both the appeals were dismissed. Yes, next. Done? No signatures. All of you come to the chamber.
ಅದು ಪೋಸ್ಟ್ ಆಗಿತ್ತು ಅನ್ಸುತ್ತೆ ನೋಡಿ. ನಿನ್ನೆ ಡೇಟ್ ಅಲ್ಲಿ ಯಾವ್ದೋ ಬೀಯಿಂಗ್ ಸ್ಪೋಕನ್ ಟು R&S ಕಂಪ್ಲೀಟ್ ಆರ್ಡರ್ ಕಾಪಿ ಬಿಲ್ಲೋ ಮಾಡಿ ಕಳಿಸಿದೀವಿ ಅನ್ಸುತ್ತೆ ನೋಡಿ. ಆ ಡಿಕ್ಟೇಷನ್ RJ ಆಗಿರೋದಾ? RJ ಆಗಿದೆ. ಅದು ಲಿಸ್ಟ್ ಆನ್ 611 ಅಂತ ಆರ್ಡರ್ ಆಗಿದೆ. ಅದು ನೀವು ಆಟೋಗ್ರಾಫ್ ಸ್ಕ್ಯಾನ್ ಆಗ್ದಲ್ಲ ಇರೋದ್ರಿಂದ ನೀವೇ ಲಿಸ್ಟ್ ಮಾಡಿಸ್ಬೇಕದು ಮತ್ತೆ ಬೀಯಿಂಗ್ ಸ್ಪೋಕನ್ ಟುಗೆ 611ಗೆ. ಅದು ಅನ್ಸುತ್ತೆ ಮೋಸ್ಟ್ಲಿ ನೀವು ಕೇಳ್ತಾ ಇರೋದು.
ಬೀಯಿಂಗ್ ಸ್ಪೋಕನ್ ಮಾಡಿಸಿದೆ ಅದನ್ನ.
ಯಾವ್ದು?
ಸೆಪರೇಟ್ ಆರ್ಡರ್ ಅಂತ
ಅದು ಆರ್ಡರ್ ಮಾಡ್ಲಿಲ್ಲ ಮೇಡಮ್. ನೀವು ಫೈಲ್ ಎಂಟೈರ್ ಆರ್ಡರ್ ಕಾಪಿ ಅಂತ ಅವ್ರು ಹೇಳಿದ್ರು, ನೀವು ಹೇಳಿರ್ಲಿಲ್ಲ. ನನ್ನ ಫೋನ್ ಮಾಡಿ ತರ್ಸ್ಕೊಂಡ್ನಲ್ಲ ಅದು. ಅಲ್ಲಿ ಆರ್ಡರ್ ಆಗಿದೆ ನೋಡಿ ಅವ್ರಿಗೆ. ಇವ್ರಿಗೆ RJಗೆ ಹೇಳಿದ್ದೀನಿ ನಾನು, ನೀವೇ ಹೇಳ್ಬಿಟ್ಟು ಕೊಡಿ ಅವ್ರಿಗೆ ಚೇಂಬರ್ ಅಲ್ಲಿ ಈ ತರ ಇದೆ ಅಂತ. ಅದೇ ಅನ್ಸುತ್ತೆ ಅದು ಲಿಸ್ಟ್. ದಾರದಲ್ಲಿ ಬರ್ದಿದ್ದೀನಿ ನೋಡಿ, ದಾರದಲ್ಲಿ ಏನೋ ಬರ್ದಿದ್ದೀನಿ ನಾನು ಅದು ಲಿಸ್ಟ್. ಕರೀತಾ ಇರೋದಂತ ನಡಿಯಪ್ಪ. ಎಲ್ಲಾರ್ನು. ಅದಕ್ಕೆ ಇಲ್ಲಿ ಏನ್ ಗೊತ್ತಾ, ಏನು ಡಿಸ್ಕಷನ್ ಮಾಡಬಾರ್ದು ಮೇಡಮ್ ಪ್ರೊಸೀಡಿಂಗ್ಸ್ ನಡೆಯುವಾಗ. ಇಲ್ಲಿ ಮಾತಾಡಿದ್ರೆ ಮಾತಾಡಿದ್ರಲ್ಲ, ಅದು ಡಿಸ್ಟರ್ಬ್ ಆಗಿರುತ್ತೆ ಮೇಡಮ್ಗೆ.